All rise. Thank you very much. Please be seated. All right, everybody. Okay, so let's get on the record, please. Thank you. We are now on the record. This is State versus Bryan Kohberger, case number CR 2922-2805. Mr. Kohberger is present in the courtroom. He's represented by Ms. Taylor, also Ms. Masseth, and also Mr. Logston. The state is represented by Mr. Thompson, Ms. Jennings, Mr. Nye, and Ms. Allen? No. Okay. Is also subbing in for Ms. Beatty. Do I have that right?
Yes, sir.
Okay, thank you. All right. We have motions to compel discovery, 4th and 5th. There have been some supplements in more recently. I think I got a couple on May 28th, I believe. So we need to sort that out. That's going to be in the morning, and that is open, obviously. And afternoon, starting at 1:30, we're going to address genetic genealogy. I think that's the plan. Okay, so starting with you, Ms. Taylor.
Thank you, Your Honor. After last week, we had one witness testify, and I have 2 additional witnesses this morning, and then there will be witnesses this afternoon in closed session as well.
Okay.
And I'd be prepared to call my next witness.
Okay, go ahead.
Call Brett Payne.
Okay. Make sure, please come forward. Raise your right hand.
You solemnly swear that the testimony you give in this case shall be the truth, the whole truth, and that's but the truth under penalty of perjury.
I do. All right, thank you, sir. Please have a seat. And then when you're seated, please state your name and spell your last.
Name is Brett Payne, last spelled P-A-Y-N-E.
All right, thank you, sir. Ms. Taylor.
Thank you. Good morning.
Morning.
Will you tell us your occupation?
I am currently employed by the Moscow Police Department as the detective corporal.
What experience do you have prior to Moscow Police Department?
I was served in the military for 6 years. 3 of those were as a commissioned officer in the military police corps.
How long have you been with Moscow Police Department?
6 years.
We're here to talk about the case of the state of Idaho versus Bryan Kohberger. Have you worked on that case?
Yes, ma'am.
What is your role in that case?
I was assigned as the case agent for Moscow PD for that investigation.
Does case agent mean you're the person in charge?
Yes, ma'am.
If I called you the lead detective, would that be a term that means the same thing as person in charge and
Yes,
case
ma'am.
agent?
Yep.
Okay, thank you. What were your general responsibilities as the lead detective in the case?
So when I became case agent, I was assigned to work the command post that was established at the Moscow Police Department, along with my partners in Iowa State Police and the FBI. We managed the command post and directed the general direction of local investigation.
Would that mean you would be a person to write warrants and affidavits in support of warrants?
Yes, ma'am.
Did you conduct or direct interviews?
Yes, ma'am.
And did you search for a suspect?
Yes, ma'am.
Were you the go-to person and the person in charge for evidence that would be brought into Moscow Police Department to support your case?
No, ma'am, I was not.
Who's in charge?
That would have been our evidence custodian.
As the lead detective, were you aware of the evidence that would be under the control of the evidence custodian?
Not entirely. I was made aware of basically the most pertinent evidence that was coming in, but was not aware of every single piece of evidence that was brought into the police.
Okay. During the course of, I guess, the investigation from November 13th forward, was there videos that were collected, like a video canvas done of the community?
Yes, ma'am, there was.
Is that something you were involved in?
No, ma'am, I was not involved in the direct collection of those videos.
Who is responsible for the video collection and knowing what videos exist?
So the way that worked was, individual investigators who went out in the community and collected those videos, brought them back to the police department and provided them to our digital forensics office, and then they were later booked in through that channel.
So the digital forensics office would be the responsible entity to receive these pieces of video surveillance, is that right?
Yes, ma'am, I would say it was a dropping off point for those pieces, yes.
And who is that person?
That was a joint effort between Detective Mowry and several people within the FBI.
Which people within the FBI?
I do not remember.
Detective Payne, I'm asking because last week, Detective Mowry told us that he wasn't in charge of these videos. And I need to know where they are. Do you have any idea who the FBI agents are that were also in charge of this?
And we could certainly find that out for you, yes, ma'am. I don't know off the top of my head.
Okay, well, I'm gonna need to do that. Let's talk a little bit about what surveillance is out there. These were cameras from different businesses, is that right?
Yes, ma'am, as well as some private residences.
Let's focus on the businesses for just a minute. Those would be collected at main points in Moscow where you might find a person of interest, is that right?
Yes, ma'am. We canvassed pretty much the entire city of Moscow looking for places that were willing to or could provide us video.
And was it also important to think about if somebody were to come into or leave Moscow, the kind of video cameras you might find on those areas?
Certainly, yes, ma'am.
And that would be the east-west road between Moscow and Pullman, is that right?
Yes, ma'am, referring to SR 270/Pullman Road. They wanted that to refer to.
I know that as the Moscow Pullman Highway.
Yep.
I think that's the same thing, or Highway 8.
Works for me.
And that goes from Pullman out towards Troy in that area.
Yes, ma'am.
Okay. And also important in that video collection would be the north-south Highway 95, the north end of Moscow and the south part of Moscow. Is that
Yes, ma'am.
okay? And so you collected business videos or had that done, but who I need to talk to about this would be Detective Mowry or an unnamed FBI agent. Do I
Or
understand that?
the agents who were the officers, investigators who collected that specific video would have written reports, to the best of my knowledge, stating such that they collected video from X, Y, and Z. That would be the best person to speak to about that particular video.
But if they collected it and gave it to Moscow Police Department or the digital evidence people, isn't it your department that I'd be looking at to say, where is this now?
Yes, ma'am.
Well, I'm going to talk about some of those specific ones, but you brought up residential cameras in that canvas as well. Are you talking about things like Ring cameras?
Yes, ma'am. Ring cameras and other sorts of private security systems that people may have had.
Ring cameras have a way of sending out a notice to Ring camera owners to check their data. Is that right?
I believe so.
Was that done in this case?
I do not remember if that was done or not.
Are you familiar with some of the Ring cameras or home surveillance videos in this case?
Yes, ma'am.
In particular, I think your affidavit talked about one on Indian Hills Road. Do you know what I'm talking about?
Yes, ma'am, I do.
How did that camera come to your attention?
I believe Detective Vargas works for MPD. She contacted the residents at that, or the person who lived at that residence, and they provided that camera footage to Detective Vargas.
Do you know why she contacted them?
I believe it was part of just the video canvas, best of my knowledge.
Now, I want to talk about some of the specific businesses, and you mentioned that I'd be looking at a police report to tell me if it existed or not. As the case manager or lead detective, are you familiar with the reports from other officers that may have talked about turning in videos?
Some of them, certainly not all of them.
Your Honor, I'm going to ask that he be handed two defendants' exhibits. They are RR and SS.
No, thank you.
One of the videos I want to talk about comes from the Red Star Coffee Company. Do you know where that business is located?
Yes, ma'am.
Where is it?
That's on Pullman Road and right next to the Steamer Station.
So the Pullman Road that's also known as Moscow Pullman Road, that within the city of Moscow?
Correct.
Okay. And if you look at exhibit RR, and if I can draw your attention to on page 2 to paragraph 9 and page 3, paragraph 9 continues over there. Based on your review of that, am I correct in believing that the Red Star surveillance video was collected and given to Moscow Police Department?
It reads that way, yes, ma'am.
Where is it?
I do not know.
Who do I ask where it is?
That would be through the evidence custodian and MPD. That'd be my best direction for you.
So I need to go to the evidence custodian and ask him to bring all of the videos out so I can watch them all to see if that one exists.
Yes, ma'am.
How many hours of videotape do you think have been collected?
A lot.
Thousands?
Yes, easily.
Detective Payne, I want to look at defendant's exhibit SS now. Don't put our away. I think we might go back there in just a minute, but SS, if I can draw your attention to paragraph 1.
Okay.
Would I be correct in believing that I should be able to have a videotape from a place called Monday's Machine?
Yes, ma'am.
Where's Monday's Machine?
I don't know where Monday's Machine is, ma'am. Does not sound familiar to me.
Can you see the address that's also listed in paragraph 1?
Yes, ma'am.
Does that help you know where Monday's Machine might be?
It'd be south of Moscow city limits if memory serves, but that's the best I can recall.
You don't know where this particular numbered address on South Main might be?
No, ma'am.
Well, let's go back to, let me ask you this. Who do I ask where that video is?
Restate what I did before is go through the evidence custodian at Moscow PD.
Let's go back to RR for a minute. And if you can turn with me to page 4. I'll draw your attention to paragraph number 21, particularly subparts B, C, D, and G. Do you see where I'm talking about?
Yes, ma'am.
And there, we're talking about 4 different businesses all within the city of Moscow. Is that right?
That is correct.
And those are on Main Street in Moscow. Is that also right?
Yes, ma'am.
All right. And if I read the first sentence in that paragraph, am I correct in believing that Moscow Police Department should be in possession of all of those videos?
It reads that way. Yes, ma'am.
Where are they?
I would have to direct you to the video that have been turned into the evidence lab at Moscow PD.
I want to talk a little bit. I'm going to move from videos now, and I want to talk a little bit about affidavits and search warrants that you wrote.
Can I ask a question? You're not asking to admit these exhibits?
You know, Your Honor, I haven't.
I just wanted to make sure.
Yeah, I haven't. The court has those in a pre-filing to put the court and counsel on notice of things we talk about. I'm not going to ask that these be admitted this way. Detective Payne didn't write them, but he's familiar with the content, so I think I have your questions answered. Thank you. Let's talk about affidavits and search warrants for a minute. Did you author affidavits in this case?
Yes, ma'am.
And did you use affidavits you authored in support of search warrants to obtain information that you wanted to take a look at?
Yes, ma'am.
And did you author the affidavit that was used for the arrest warrant for Bryan Kohberger?
Yes, ma'am.
What did you rely on when you wrote these affidavits?
Be more specific.
Yes, let's focus on the affidavit for the AT&T records. There were 2 search warrants on December 23rd, 2022. Are you with me?
Yes, ma'am.
Okay, so let's talk about those search warrants and the affidavit. First, the affidavit. What did you rely on in the affidavit you wrote for the first AT&T search warrant on December 23rd, 2022?
It was a conglomerate of interviews, data received from cell phones, my observations of some surveillance footage that was taking place, various other things. Go down the line. If you could be more specific on specific parts, I'd be happy to tell you what I'd like.
Okay. There was a part of the affidavit where you talked about WSU officers identifying white Elantras.
Yes, ma'am.
And there was a part of the affidavit where you talked about 2011 to 2013 Elantras, and then it expanded to 2016 to include the year of 2016 Elantras.
Yes, ma'am.
What I want to know first is what you relied on to expand that search from 2013 to include 14, 15, and 16.
That information was provided to FBI Special Agent Imel. He's a vehicle identification specialist. He used snapshots from the previously mentioned surveillance videos, and that was his determination on the types of vehicles we should be looking for, rather the year range we should look for. It would be in his report, we'd be more specific, but that was what I based the affidavit off of, that portion of it.
I understand as far as when we get to 2013, but when we go beyond that, what did you rely on to get beyond that?
It would have been his input as an expert in vehicle identification. That's what.
Okay.
we relied on.
Part of your affidavit talks about WSU officers finding white Elantras. And I believe there was an officer that you had some communication with. Do you recall the date you had that communication?
I do not recall the date.
Did you have some messaging system exchange with this officer to talk about that?
Yes, ma'am.
Is that the only means of communication you had with this officer?
No, ma'am. I believe I spoke to him on the telephone as well.
When you spoke to him on the telephone, how did that relate to the date of the messaging?
It would have likely been, if memory serves, it would likely been that same day.
Okay. Does December 20th, 2022 sound familiar to you?
Yes, ma'am.
And so this conversation with this officer from Washington, it related backwards to when he noticed an Elantra, is that right?
Yes, ma'am.
But when he noticed it, you didn't know about that yet. Is that also correct?
That is correct.
Okay, so you don't know about him or talk to him until December 20th, 2022, correct?
Yes, that's correct.
In your affidavits, did you rely on cell phone information and cell phone location information?
Yes, ma'am.
Did you work with cell phone records yourself?
No, ma'am.
did you see cell phone records yourself?
Yes, ma'am, I did.
When was the first time you saw cell phone records that were attributed to Bryan Kohberger?
I do not remember what date that was.
Well, maybe you can give me an estimate. We know on the 20th, you're talking to WSU about an observation from a month before. And we know on December 23rd, you're asking for AT&T warrants for information. Can you narrow
That's
it
a
down?
yes.
Sorry, Judge.
That's a yes. You can, I just want to get the record. Yes,
Yes, that's
okay,
correct.
thank you.
So between those 2 days, does that help you identify the first time you saw cell phone records related to Bryan Kohberger?
Memory serves, the first time I saw any cell phone records related to Bryan Kohberger was after we received the return from the first search warrant.
Just to be sure I'm tracking with you, when you say the return from the first search warrant, we're talking about the first AT&T warrant.
Yes,
Is
ma'am.
that right?
That's correct.
And in that warrant, you were seeking 48 hours worth of records, is that right?
Yes, ma'am.
Okay. So if I call those the 48-hour records, we'll both be on the same page?
Yep.
All right. You wrote your second AT&T warrant for a much longer period of phone records that same day, December 23rd, correct?
Yes, ma'am, that's correct.
How far ahead of that warrant did you see the records?
It would have been upon the receipt of the 48-hour records that came in from AT&T. Immediately after receiving those, I began writing that second section of the second AT&T warrant for the longer period. If that makes sense.
It does. So you get these records and you take a look at them and you start writing your warrant. Is that right?
The records were provided to FBI Special Agent Balance, who began deciphering them. I'm not an expert in cell phone records.
That was the next thing I was going to ask you.
So, no, ma'am, I'm not. So, he was the one who was conveying that information to me so I could understand what it was.
So do you get the records and then get them to him somehow?
Yes, ma'am.
The records do they go directly to Balance?
I do not recall what the distribution was on the return itself. I do not recall that.
Are you and Balance exchanging emails about these records?
No, ma'am, not that I remember.
How did you get them to him?
We were co-located. At the time, Detective Balance was at the Moscow Police Department about 30 feet down the hallway.
Are the two of you exchanging text messaging during this time?
I do not remember if we texted during that time.
I may have a record that would refresh your memory. I'm certainly not seeking to have these admitted, but I'd like to hand him some records to see if we can refresh his memory. Do you recognize what's been placed in front of you?
No, ma'am, I do not.
Okay. Does reading the content of some December 23rd messages refresh your recollection about participating in text messages with Nicholas Balance?
It really does not, ma'am.
Will you look at, there's 3 separate stapled documents. Will you move that one and go to the next one?
Still on December 23rd?
Yeah.
I do vaguely remember that exchange, the one at the top of the second.
Is that the one that starts with you identifying yourself?
No, ma'am, it starts with the message says, group text for this weekend, Maria, Nick, Ed, Brett, and Darren.
You look at that third one.
Seems vaguely familiar.
Okay. So just so I'm clear then, Nick Balance is at Moscow Police Department when you're getting, on December 23rd, when you're getting these 2 warrants. Is that right?
If memory serves, that's correct.
Okay. Well, you told me that you're not the guy who understands how to interpret these records. Do you know anything about cell phone towers?
Very little, ma'am.
So when you wrote this second AT&T warrant, you have possession of Bryan Kohberger's call detail records or AT&T records, but you don't know what they mean, so you're relying on somebody else.
Yes, ma'am.
Who all did you rely on?
Mainly it was Special Agent Balance. He was my main point of contact for understanding what was going on.
Okay. In fact, in your affidavit for the second AT&T report, there's a couple of maps in there. Is that right?
Yes, ma'am.
And one of them has some video camera information. That's the first map. Where did that come from?
I do not recall if you have a copy of it. I can refresh my memory and tell you.
I bet I do. I have what we've marked defendants B.
Are you referring to there's two maps, the WSU focus map you're referring to? It's
Yeah.
completely washed out on this copy. I can't even see where it is.
It's hard to see, isn't it? What I want to know is what you relied on to get that first one that talks about WSU and the cameras of WSU. Where'd you get that?
Yes, ma'am. So Special Agent Rob Hilley with the FBI was also co-located with us. He was tasked with analyzing that video from WSU and the surrounding area. So it was a conversation between he and I, pointing out areas of locations where the car was likely seen on surveillance footage. And that's what I relied upon to create that map.
So you created that map. How?
Through PowerPoint, I believe, ma'am, memory serves.
You saved your work on that?
Yes, ma'am.
Let's go to the next map. That one would appear to be a trail or a path from south of Moscow back towards Lewiston or back towards Polk. Is that right?
Yes, ma'am.
Where did you get that map?
Same thing. It was just created using open source satellite imagery, and I think it was PowerPoint.
Did you create that?
Yes, ma'am.
Where did you get the information to draw that trail?
So that was used from the cell phone records referred to me by Special Agent Balance on his interpretation of possible places where someone could have driven between the location that it starts there and then back to Pullman.
So you did this on some open source mapping, not anything from Nick Balance creating a visual for you.
No, ma'am. I did view a draft report from Special Agent Balance to help me conceptualize this, but it did not look like this map.
Where's that draft report?
It is, best of my knowledge, it's already been provided to the prosecutor's office through the FBI channels.
Is this the lengthy past draft report or is it a different draft report?
It would have to be the draft cast report. That's the only cast report I'm aware of from Special Agent Balance.
So on December 23rd, are you saying you looked at this past draft report to make that map that went into your affidavit to get the second set of records?
Yes, ma'am.
The one that was given to us in July of last year?
I don't know when you got it.
How many versions of that cast draft report have you seen?
I've only seen that one, ma'am. That's the only one I'm aware of.
All right. And from the FBI, we have Agent Balance and Agent Hilley at Moscow Police Department with you. Yes,
Yes, ma'am.
and all of this work is done with verbal communication, is that right?
The majority of it, yes, ma'am.
And Nick Balance's cast draft report.
Correct.
And I think Special Agent Imel's vehicle identification.
Yes, ma'am.
Okay. Let's talk about what you were seeking to get in this. Well, let me ask this before I leave the second search warrant. Is there anything else you relied on to obtain that second search warrant to compose your affidavit?
Like I said earlier, we relied on cell phone records from surviving roommates as well as the victims. We relied on interviews with the two surviving roommates that were present at the time. We relied on the surveillance footage, cell phone data. I'd have to go paragraph by paragraph, but that's what jumps to mind.
Of those things, are you relying on other people's work to put that all together?
Yes, ma'am.
Now I'm ready to talk about the things that same day as the first one. And was there anything else from AT&T that you saw or relied on to get the second one off the ground?
No, ma'am.
And in the first AT&T search warrant, are you aware that part of the request was for timing advance reports?
Yes, ma'am.
And in fact, that also appears in your second search warrant request, right?
Yes, ma'am.
All right. And not only do you ask for the timing advance reports from AT&T, you ask for them from several other companies, correct? Verizon's version of it, T-Mobile's version of this kind of timing advance report, is that right?
Yes, ma'am.
All right. When was the first time you saw AT&T's timing advance?
I do not recall when I first saw it.
Where is it?
To the best of my knowledge, all that information from those returns has been provided to the prosecutor's office.
If I tell you I don't have a timing advance report or any from the other phone companies, where do I look for them?
I would direct you back to the prosecutor's office. Everything that Moscow PD received, in that realm, we have turned over to my knowledge.
But you know you've seen this report, is that right?
I do not recall if I've seen the timing advance reports. I'd have to see what it even looked like to know if I'd seen it.
Do you know what it is?
Not particularly. I'm no expert.
Okay, you wrote the search warrant though, right?
Yes, ma'am.
Well, how did you get the language for that if you don't know what this is?
So there's no secret that I rely heavily on people who are very highly educated in these topic areas to write this search warrant. So that language was likely conveyed to me through people who know much more than myself about cell phone data.
Who are those people?
Like I said, FBI agent Balance and Detective Mowry were probably my two main points of contact for helping me with that language.
During the course of your investigation and work on the case that became the case that we're here for now, did you communicate with Agent Balance by email?
Yes, ma'am.
And did you communicate with other FBI agents by email?
Yes, ma'am.
And did that relate to the investigation of the scene and later the investigation of Bryan Kohberger?
Certainly, yes, ma'am.
Were those communications that assisted you in preparing affidavits and search warrants to carry out your duties in the case?
I do not recall.
But you recall the emails themselves.
I recall sending emails to FBI agents, yes, but
And-
specifics.
And receiving them?
Yes, ma'am.
Where are those emails now?
All emails that Moscow PD is aware of have been turned over to the prosecutor's office.
Your Honor, if I can have just a minute.
Sure, thank you.
Thank you. I don't have any other questions for now, but I think you have a couple of exhibits on that front end. If you don't need them for us, maybe I'll take them back.
Well, hold on. Do you have any questions?
Yes, I'll.
Yes, okay. I thought you were just stepping off, so. Jennings?
Yes, thank you.
Go ahead.
Morning, sir.
Good work.
your knowledge, has all the evidence in Moscow Police Department's possession been turned over to the state for us to discover?
Yes, ma'am.
Have you facilitated the defense visiting MPD to review the physical evidence in this case?
Yes, ma'am.
Approximately how many times have you done that?
I had to guess, I'd say 6.
Now, let's talk specifically about this video surveillance. Explain to me the process for collecting video surveillance.
So in this investigation, the way that played out was we directed the investigators to go into the community and collect any available surveillance footage there was. Once they had done that, they were tasked with bringing it back to Moscow Police Department, placing it in the digital forensics lab, and then writing a supplemental report on where they collected that information. That was the process.
Do you know how many agencies helped in this video canvass?
Certainly the FBI and the Idaho State Police. I'm not sure if any other agencies helped. I don't know.
Do you know approximately how many agents were out collecting video?
Easily over a dozen. I don't know the specific number, but
Isn't it true that investigators collected video surveillance from approximately 79 businesses
yes, ma'am.
and approximately 10 residences? So let's talk about the areas that Ms. Taylor mentioned. Isn't it true that there's other surveillance video capturing the Moscow Pullman Highway, specifically on the way to Pullman?
Yes, ma'am. There's-
Isn't it true we've turned over video for banks
Yes,
on
ma'am.
that highway? Isn't it true we've turned over surveillance for stores on that highway?
Yes,
Isn't it true we've turned over video for gas stations?
yes,
Now let's talk about the Troy Highway towards Troy. Isn't it true we've turned over surveillance video for fast food restaurants,
yes,
gas stations?
yes,
And now US 95 towards Coeur d'Alene. Isn't it true we've turned over surveillance video for hardware stores,
yes,
gas stations?
yes,
Now, what about US 95 towards Lewiston? Isn't it true we've turned over surveillance video for gas stations,
yes,
as well as apartments?
yes.
Now let's move to your PC affidavit. Can you explain to me what did the investigation look like during the time that you were writing that affidavit?
So as I said, the command center was established at the Moscow Police Department. The command center consisted of myself and numerous partners from the FBI and the Idaho State Police. We were all co-located there at Moscow. We also had individual sections assigned to do various tasks, collect video, conduct interviews, so on and so forth. The majority of those people were also co-located at the Moscow Police Department. So as the process for developing this affidavit began, those people would just come into the command center and relay information that was deemed to be critical or important. The reason for that was to shorten the chain of information to make sure that the folks, myself and my partners in the command post, got the clearest view of what the investigators on the ground were actually retrieving and learning as this went on. As they relay that to me, I can put that into the affidavit.
And is that standard to rely on what other investigators tell you when you're applying for warrants?
Absolutely.
And is that what you did?
Yes, ma'am.
And is what you relied upon detailed in your probable cause affidavit?
Yes.
Now, talking about the timing advance records, are you aware that AT&T didn't provide timing advance records in December of 2022?
I do not remember.
Are you aware that they did not start providing those records until May of 2023?
Objection leading.
Cross-examination.
It is overruled. Go ahead.
I'll re-ask. Are you aware that AT&T did not start providing those records until May of 2023?
Yes.
I don't have anything further.
Thank you. Ms. Taylor?
Thanks. Let's start there. May of 2023. Do you have timing advance records now? from May of 2023?
I would have to direct you to Detective Mallory to answer that question. Don't know.
Okay. Did you write a new warrant for them in May of 2023?
I do not recall.
If you included them in two separate warrants in December of 2022, but they didn't find them, why would you do that?
It was the language that was suggested to me to write the affidavit, so.
Language suggested by an FBI agent who's an expert in the field?
Yes, ma'am.
Yes. And do you know if he saw the timing advance reports?
I do not know.
All right. Now, those first and second AT&T warrants were how many hours from receiving the return on the first one until the second one was given to Judge Marshall at 4:45?
I do not remember.
Not very many hours, though. Would that be fair?
Likely not.
I want to talk a little bit more about the video and what's been turned over and what hasn't been turned over to us. And I want to focus a little bit on South US 95. Do you recall that south of Moscow on US 95 is the path that you put in your search warrant and affidavit alleging that Bryan Kohberger left Moscow going south on US 95?
Yes, ma'am.
All right. And are you aware that one of the videos that you gave us, the coffee shop there on South 95, that leaving Moscow, you have to pass that covers 5 a.m. to 6 a.m.?
I do not recall the time frame for that.
And so the time frame in these videos would matter, right?
Certainly.
The time frame in the videos to be meaningful would need to cover a time that surrounds the allegations against Mr. Kohberger. Is that fair to say?
You can say that, yes.
Okay. And are you aware that Watson Kari Construction had a video, and that also has a very limited time frame, like 5 a.m., just 1 hour of video also?
Sounds vaguely familiar, yes.
And that's also south on Highway 95, is that right?
Yes, ma'am.
And the one we talked about today, Monday's machine that nobody could find, that clearly was given to Moscow Police Department, that's also south on 95.
Yes, ma'am.
Okay. I understand that you had a lot of help on canvassing and collecting things. There was a lot to do. But as the lead agent and the lead department, is there some kind of inventory of these videos, like a general inventory that would help me know what you have and why you don't have the relevant timeframes?
The inventory that would be most useful to you is the inventory of evidence that has been booked into the Moscow Police Department. That's the inventory.
And I did come see the evidence. That's fair. I did come see the evidence. We didn't watch videos together though, did we?
No, ma'am.
And would you agree that that evidence is on thumb drives with stickies on papers that tell us different things, but not like an inventory of what's on each thumb drive?
I am not aware of an inventory of each individual thumb drive.
Okay. So for us to do that together would take some days to inventory it all together. Is that right?
Yes, ma'am.
And that's my best way to try to find this Monday's machine
Sure.
and Watson Kari Construction.
Yes, ma'am.
That's it. Thanks.
All right, Ms. Taylor, anything to follow up on that, Ms. Jennings?
Oh, just one second. Thank you. I just want to clarify what's in your probable cause affidavit. Does your probable cause affidavit state that Kohberger or a white Elantra went on US 95 south of Moscow?
No, it's not.
Okay, what does it state?
Memory serves states that the next time, well, that states that a vehicle was seen leaving the area of the crime scene, on King Road, leaving via Walenta Drive, which heads south from that area, and then terminates on Conestoga and Moose River Drive. That's what the probable cause affidavit states.
And to your knowledge, are there other paths of travel south of Moscow besides US 95?
Yes,
And what's that other route?
I believe the one that was referenced in the affidavit goes from Blues River Drive, which turns into Sand Road at the state line, not the Idaho-Washington state line. That road continues westbound until south of Pullman and eventually leads north into Pullman at Bishop Boulevard, if memory serves.
And does that path of travel go by Watson Carry Construction?
I do not believe it does.
Did you attempt to obtain surveillance on that path of travel that doesn't go through 95?
Yes, we did.
And were you successful?
I don't believe we were.
I don't have anything further.
Okay, thank you. Ms. Taylor?
Are you testifying that Mr. Kohberger did not use Highway 95 south of Moscow on November 13th?
I'm testifying that there are various routes that a person could take south of Moscow to include Highway 95. There are also several others.
Which one does your map depict?
I believe the map starts well south of Moscow, forward more towards Genesee, and there is the line that starts there. However, I would direct you to the paragraph at the beginning of the map that says this is a possible route to travel between the two locations.
So you're just not sure.
Yes, ma'am.
That would include then Highway 95 south of Moscow.
Yes, ma'am.
And that would include other possible routes.
Yes, ma'am.
How many video surveillance attempts did you make to get video from businesses or homes on all of those routes?
I do not recall, but it continued for some time, attempting to find additional video footage.
What did you find?
Nothing to my recollection.
Not one video depicting the car.
To my memory, though.
Good enough, thanks.
All right. Thank you. Okay, great. Can this, Detective, Payne be excused at this point?
He can be, thank you.
Okay, any objections? All right. Thank you, sir. Thanks for being here. You can, you're free to stay or leave.
Thanks, sir.
Thank you.
Your Honor, we call Syray.
Okay, thank you. Thanks, sir. Thank you.
Do you solemnly swear that the testimony you give in this case shall be the truth, the whole truth, and nothing but the truth, and the penalty of perjury?
I do. Right. Thank you, Sue. So you go ahead and have a seat there, and then please state your name and spell your last. I, Ray, R-A-Y. Thanks, sir. Ms. Taylor.
Thank you. Good morning.
Good morning.
Will you tell us what you do?
I have a handful of different jobs, but primarily for my role here, I do a lot of consulting, analysis, and evaluating geolocation data as it pertains to mobile devices.
Let's talk about how you got to that place where you, by consultation on devices and geolocation.
Okay.
What background led you to this job?
I started with a law enforcement background. I started my law enforcement career in 1995 in Arizona. Started working with the first set of cell phone records in that capacity in 97, late 1997. There wasn't a lot of training. Obviously, cell phone technology and the use of that in criminal investigations was very new and novel at that time. So most of my early training came directly from the carriers. If I was working a case with Verizon or AT&T, I would work directly with Verizon or AT&T engineers to understand the records, what they meant, how to map them, how to interpret it. In 2000, I started a very small police department in Arizona. In 2000, I transferred to a much larger police department in the Phoenix area. When I made that transition, I took more of an investigative role. I was previously a patrol officer. That investigative role, I started with a DEA task force where I worked with drug narcotic interdictions, and the primary role there was working with cell phone records. So I had some more training experience in that capacity. In 2001, late 2001, I left that position and I went into a full-time investigations position. I started with sex crimes and child crimes. Again, using cell phone records and attending what training was available. Again, most of that is from the carriers directly. About 2004, I moved out of sex crimes and child crimes into persons crimes or violent crimes. So any type of a dangerous or violent crime against a person. Continuing to work with cell phone records and attending what training I could. In 2008, I was promoted to sergeant and I was immediately put into a homicide robbery sergeant's position where I stayed until 2010. Around 2004, I started doing a lot of work with cell site simulators. And that is a piece of equipment that allows you to physically go out in the field and find a mobile device. In a very brief summary, it's the ability to create a fake cell tower that is mobile, it's in a vehicle. And if I can analyze your phone records and determine a rough area that you're at, I can put this mobile platform in that area. Your phone will register to it and I can physically track the phones. It's in courtrooms, in a bedroom, wherever it may be. In 2007, our agency purchased that equipment. So prior to that, I was working with other agencies looking for devices using it. 2007, we purchased our own equipment. That purchase also prompted more training. There was a company, it's owned by Boeing. They came in and I had 80 hours at that point specific to cellular network engineering, how to go out and actually conduct these surveys to understand how a particular cell phone network works in a particular area, how to replicate, how to create a cell site that looks legitimate in that area. I worked with that company for a number of years in doing that, hundreds of hours worth of back and forth working, actually going out in the field and doing this. In 2010, I had an opportunity to go to Afghanistan as an advisor, in charge of an undercover Afghan police team that targeted IED cells. And again, we would look at different types of technology that we could leverage in doing that. I came back in late 2010, early 2011, and went back to the police department. In 2012, our department created a position that this was a full-time position. Now that's all I did was track phones pretty much every day, using cell site simulators, using phone records, whatever technology we could leverage. Because of the lack of training that was available when I was a younger officer, in 2007, I started a training company. At the time it was called Phoenix Training. And I created a training company to provide law enforcement training, specifically as it relates to cell phone records. I've been providing that training from 2007 up to about 2013 now. I was really frustrated with the lack of software and training available to law enforcement. It's very complex and clunky, for lack of a better term. So I began researching and teaching myself how to do some basic computer programming. And I wrote a program that I could take phone records from any carrier in the United States and I could put it in this program and it would immediately map hundreds, if not thousands of connections. It was pretty unique at the time. There just wasn't a lot of options out there that was doing the geolocation. There was a lot of analytics to who's calling who and how often they call that person. But specifically to put it on a map for detailed geolocation data, there was a big gap in the market. It worked. It worked really, really well. And at the time, because we were tracking phones in the field, it gave me this very unique opportunity where I could use a search warrant, get phone records, analyze the phone records, come up with a hypothesis that this phone is most likely Thursday at 2 a.m. going to be in this neighborhood, and then physically go to that location to recover the phone. And then I could evaluate, was I right? Was I wrong? Do I need to tweak something? Mid-2013, our agency was assisting a lot of other agencies because we had, for lack of a better term, we had progressed significantly on our ability to find the phones. I had a lot of agencies asking me for a copy of my mapping program, and I was just about at 20 years at that point. I realized maybe it's time to go do something else. So in May of 2014, I retired from the police department and I started a company called ZETX, ZETX. And we offered a couple different things. So we had the mapping program that I just described. Obviously, when I'm running it on my laptop, it can be a little clunky. It doesn't have to be perfect. When we started a business, we actually hired computer engineers to come in and take what I had written and scale it to a national platform. So we offered the mapping services, which was both real-time and historical. We took that original training class that I had built and we scaled it out. So we had a basic 40-hour that would just give you the nuts and bolts of how to look at phone records, what they mean, what type of records to obtain. We also started a subject matter expert course. It was one of the first courses in the country where law enforcement could actually come in and become certified as subject matter experts in this field. Did some training courses as well that we created on drive testing, so the ability to go out and scan and monitor some of their networks. Because of those two features, my job duties changed dramatically, where I found myself consulting with law enforcement daily, sometimes multiple times in a day, on cases very similar to this case, where I would have a law enforcement agency that's using our product or has attended our training that would call me for some type of review or analysis. And I've lost count. It's thousands and thousands of cases. To put that in perspective for some just general numbers, I sold this company in 2021. At that time, around 2021, 2022, the system had mapped over 2 billion phone calls in the United States. We were seeing thousands of uploads a week. We had created this program in 2014 that if any law enforcement agency in the country called us because they had some type of crime, we would overnight them a drive test scanner, which gives them the ability to go out and do a forensic examination of cell tower networks. It was no cost. We ate all of the cost of this. So we paid for the scanners. Initially we paid for the shipping. And the idea there is we wanted to create a national tower database that would have just a collection of drive tests. I want to say we have over 3 million towers in that database today that have been scanned or measured in some capacity. I am unaware of any other database in the world like it. And we use that to feed the mapping platform to increase the accuracy of the mapping. Something that we did that was very unique with our company is we actually provided an estimated coverage area. So instead of just saying this phone connected to this cell site and the antenna points north, we would give the person doing the analysis a general idea of where that phone could possibly be within a radius. We were the only ones doing it when we did this. Since then, since 2014, more recently, since about 2020, pretty much the rest of the industry has adopted, if not the same standard, a very similar standard. So the company we were using to do the drive test data is a company by the name of Rohde, R-O-H-D-E, and Schwarz, S-C-H-W-A-R-Z. They're a German company out of Munich. They've adopted the way that we were doing some of the ranging. The FBI task team has adopted that, has actually brought that tower density is what is the general term for it. And it's now a feature in the CASBIS program. So through the years with training, I've probably been involved in training 30, maybe 35,000 law enforcement officers from around the country. We had about 650 law enforcement agencies within the United States. At some point, all of the federal agencies have used our products in their training. And I've done quite a bit of consulting internationally as well. Towards the end of that period, we started working more with Rohde and Schwarz. Rohde and Schwarz decided that they wanted to look at the ability to implement a cell site simulator in the United States. They had one for Europe. They were considering doing it for the United States. So they sent me their first one for the United States, and I worked with their engineers for about a year, testing it, reviewing it, improving it. So another several hundred hours there. I've tried to figure out how many of these missions, if you will, of going out and finding a phone or looking at phone records, and it is literally thousands and thousands of hours at this point. I can't tell you specific number. But that would be the background.
Sounds like your background is mostly in law enforcement, and then you moved into a specialty with cell phones, cell towers, drive testing, radio waves, all of that kind of thing.
That would be correct.
Through that and through the training of other officers to do this work and to use your program, have you testified as an expert in this field?
I have. If it's not 100 times, it's right there near it. Roughly 100 times in both state and federal.
And have you been qualified as an expert in state courts,
Yes,
in federal courts?
yes.
How about Idaho?
Don't think I have in Idaho. I can't, I've consulted on a lot of cases in Idaho, but I don't think I've ever had testimony in Idaho.
This your first time then?
I believe it is.
Generally, when you work, and I'm talking about when you've done your consulting work or worked with an agency to do what you do to review the records and to analyze the data, do you usually work with the defense?
This is the first time I've ever testified for this.
Fair to say you usually are a prosecution witness?
That is a very fair statement.
Well, here you are, and you're working with us in Mr. Kohberger's case. What's your role in this case?
Trying to conduct an analysis of all of the geolocation data, at this point still focused primarily on Mr. Kohberger's device, ultimately all devices, but any geolocation data, which is the ability to look at a specific area, whatever range or size that might be at a specific time, and put some type of accuracy and reliability to a phone's travel. Maybe it's stagnant when it's moving, when it's not moving, when it's off, it's on, those type of things. But specifically as it relates to network, so the cellular network or a Wi-Fi network, I am not a forensics digital guy. I don't get into cell extractions. I'm not looking at the metadata on the phone. I'm looking at it very much as a network.
If I can make a rough distinction, you're not the person that's going to tell me who they called and which Facebook groups they might be a part of. You're not going to look at the data from the phone like photographs, but you're going to tell me the places this phone went and how it was used while it went somewhere.
Kind of. Let me clean that up a little bit. I will look first at where I believe the phone went, where it traveled, how it got there, how long it took, possible routes. And then to your point, I call it cooperative data. I'm then going to seek out all that data you just talked about to say, okay, well, we have these 3 photographs, we have this piece of surveillance video, we have these 4 receipts. And I'm going to overlay it with my analysis so that I can corroborate the analysis accurate, or maybe we see activity associated with that person and the phone's not there. Does that person just not have the phone, or is part of our analysis wrong? Maybe surveillance details wrong. We don't know. So eventually I will get back to that data you're talking about, but I'm not the guy that's going to go out and extract that data.
Would it be fair to say that that's data that you would use in a final analysis as it comes in from other sources, that you're the go-to for me to understand how a phone works with a tower and how it moves between towers if the phone's in motion somewhere?
Yes, 100%.
You talked a little bit about drive test data or drive testing, and that being part of the company that you developed and part of the work that you've done. Is that helpful in understanding the ultimate picture?
Depending on the type of records we're dealing with, it can be very helpful. When we're looking at just basic call detail records, CDRs, a lot of times we're just getting connections to a particular cell site, and we can say a PSI of that cell site. Sometimes the frequencies that are used. Drive testing is really the only way to get a little bit more specific with where that phone may be. But more importantly, we can start to rule out areas we know it's not by drive testing. So just think of drive testing as a forensic evaluation of the actual cellular network in a particular area.
Fair enough. Are you familiar with AT&T records?
I am intimately familiar with AT&T records.
How long do you think you've been working with AT&T records?
28 years.
In our case that we're here on today, have you reviewed any AT&T records that relate to Mr. Kohberger?
I have.
What have you reviewed?
What AT&T refers to as their There are regular CDRs, which is a report AU as an atom unit. I have identified the report CT as in Charles Tom, which is the subscriber information. There's a really weird name called locabor, which is AT&T's attempt to estimate general locations using latitude and longitude. I don't want to say GPS because it is different than GPS. I believe I've looked at some ping data from December. For the most part, that's what I've reviewed so far.
Have you looked at two separate AT&T warrant returns from December 23rd, 2022?
I have.
In your experience with working with AT&T records, is it common or uncommon to have two warrants, one that relies on the content of the first and the same day?
It's not uncommon to see a small time period that produces results that would increase the desire, the need for a bigger time period of records. Seeing that entire process happen twice in the same day is extremely rare.
Well, the first AT&T record, we called it today the 48-hour AT&T record of Bryan's call detail record. If you were to take that and do an analysis on the call detail record, how long would that take?
Depends on the analysis. So I'll qualify that answer with looking at what was put into the second warrant that shows us at least parts of that analysis to include a route that was identified. To do it reliably and feel comfortable that I'm accurate, at least 3 hours. And that's if you know what you're doing and you have all the tools at your disposal. Arguably, you could spend half a day or more doing that very easily.
To do that, do you just take these records, printed copy, and know what's on there, or do you have to do something with those records?
You have to use some type of a mapping platform software, and you would take the digital copy, which is typically a text file, you would import it into that program, which would then map everything. But if I'm going to use those results, search warrant affidavit, for example, there's a process that I'm going to go through to confirm the accuracy, because in theory, if I'm wrong, the entire linchpin of that case is now hinged on this affidavit that I wrote. So before I commit to swearing out to an affidavit, hey, this is what the phone is doing, X, Y, and Z, there's a further process of just mapping it to validate it. In this case, there's a lot of time distance measurements that need to be performed that can be extremely time consuming. There's some ulterior issues that come up with how that phone is interacting with other cell sites that needs to be analyzed. Again, saying that a very qualified, competent investigator spending half a day just coming up with that basic summary is very reasonable.
In that half a day, you would put that record into a computer program and a map would be produced?
Correct.
What other information besides that call detail record would you need to do this analysis?
In this case, I would want the call detail records. I would want the locabor, it's LOCAVR. And I would want the regional cell tower list from AT&T.
Does AT&T generally provide that regional cell tower list inside of its record that it produces pursuant to the search warrant?
No, I would actually say by policy, they do not. It's a very large file. It typically does not transmit very well to government email. So they would direct users of where they could go online and download.
And have you looked at this record, the 48-hour AT&T search warrant record, the return on that?
I have.
Did that include the regional tower list?
It did not.
Okay. So if you are doing this analysis, you put CDR records into a computer program, you put a regional tower list into the computer program. What does it produce?
The CDRs would show me cell sites that the phone connected to. In this case, even within 48 hours, there's hundreds of those cell sites. So it would take a while to really look at that. The regional cell site list would show me the cell towers that the phone's not interacting with, which can be just as important.
Does it spit out product to you, or does it create something that you can reference to write your next warrant?
Depending on which mapping platform you're using, they all create some type of a map that the person doing the analysis on can interact with, and they can change things, they can save things, they can create work product. Depending on that platform, that's saved in different types of maps, but yes, all of them would have some type of a mapping platform.
Okay. Would that be consistent with this past draft that we heard about earlier?
It's my opinion that Corporal Payne probably is misusing some terms there. I don't see any possibility of the FBI CAS team producing a CAS draft report on the 23rd. I think he's probably mistaken that he saw some type of CAS work product, which would be this map, before they export all those results into a report. So I believe that he probably saw some mapping through a mapping platform. It would really surprise me if there was a physical report. It would be completely out of character.
In that first AT&T report, did you, or request search warrant and affidavit, did you see the request for advanced timing reports?
I did. It's in both search warrants.
Did you get a copy of that and either return?
I have not seen any timing data in this case.
In December of 2022, did AT&T have this advanced timing report?
They absolutely did.
Was it something that they could produce?
It absolutely was.
And in May of 2023, but how's it different to that May of 2023?
Prior to May of 2023, only certain agencies were receiving this timing report, the FBI being one of them. What was referenced earlier about the May 23 date, that is when AT&T started offering the same type of reports. It's a little different, but it's the basic timing report to the state and local law enforcement. Prior to that date, state and local law enforcement would have to leverage these reports through federal agencies that had access to them.
Let's talk about the return on the second AT&T warrant. Did that have the tower list, the regional tower list in it?
It did not.
Did it have call detail records?
It did.
What time span?
I believe it's from June 23rd of 2022. The historical was as of the date of December 23rd, but there was also a real-time PIN register that was added that extended, I want to say. I believe it's from June 23rd of 2022. The historical was as of the date of December 23rd, but there was also a real-time PIN register that was added that extended, I want to say, to the end of December, maybe very first of January.
What's a real-time PIN register?
So the second search warrant asked for a couple of different things. Historical records going back to June 23rd to the current date, which was December 23rd. The second piece that was asked for is real-time data from the network, which is commonly referred to as a PIN register or trap and trace. And it's the ability of law enforcement to monitor network connections in real time. So as that phone connects to the network for certain reasons, I can see those connections. It's not a wiretap. I can't hear anything. I can't see content, but I can tell the phone is connected to a particular cell tower. There's also what's referred to as ping data, and that's going to be AT&T's estimation of where the phone is at, and that's provided by latitude and longitude, and that comes in every 15 minutes.
What is the purpose of one of those devices?
I should probably clarify. The third thing was the authorization for a cell site simulator. So it was a combination of all of these. Just as a matter of policy, and I think pretty much every law enforcement agency in the world has adopted this if they can. To use the cell site simulator, you want to see a real-time feed of the phone. Otherwise, you're driving in circles where the phone may not be. So it gives law enforcement the ability to have a general understanding of where a phone is operating or functioning. And then I can use the cell site simulator to do it. There's a number of reasons an agency might do this. This search warrant actually says they were requesting these because they were trying to locate where Mr. Kohberger was.
Going to the understanding what's happening right now, is that used so that you don't just know where the phone was 5 minutes ago, but you know where it is right now?
Within a time period, it's not a perfect system. There is a little bit of a delay and the information comes in intermittently. So it's not a real-time feed of giving constant evaluation of where that phone is. But if you know what you're looking at and you've done it long enough, you can get a pretty good idea.
I heard you say that this is to try to find out where Mr. Kohberger is. In the information that supported this warrant, didn't they already know where Mr. Kohberger was?
I reviewed a lot of documents that clearly state not only did they know where he was, they had a surveillance team with eyes on. So yes, it would be unusual for an agency to request this type of equipment. And I need to qualify that. This truck driving around is about $1 million. It's not something you just park in the garage at night. It's a very expensive resource. It's a very technical resource that requires a lot of training and skill to use properly. So typically when it's used, it is used for, hey, we don't know where this person is at and we need to find them. And to be very honest, I don't have an issue with that part. I've used it 1,000 times. It's a good tool. It's a great tool. However, if I know where a subject is and I'm physically watching him, it's probably disingenuous for me to get a search warrant justifying it that I need to find him.
Makes sense. Thank you. I want to switch gears and talk about the CAST-BIZ program.
Okay.
Are you familiar with the CAST-BIZ program?
I am.
Why?
I've worked with a lot of agencies that have used it and accessed it. So I've worked on cases where we've used different mapping platforms to do kind of a compare and contrast as a peer review. So they would create a work product, we would create a work product, and we would check each other's work. Because at the end of the day, we're just looking for the accuracy. We want to see if there's any errors in that. I would say I probably have worked with the CAST-BIZ reports several dozen times, maybe as many as 50. I'm aware of some of the updates they've made. Like I mentioned earlier, I'm aware that they have added a feature that you can now input tower density, so you can create these estimated ranges, if you will. And I'm very familiar with the basic settings that have certain controls you can do, like time zone. What time zone am I going to have? Am I going to use the coverage density? Am I going to save my work? Am I going to just exit the program? I physically have seen those features a number of times.
As it relates to this particular case, have you had a chance to look at any exhibits prepared by Detective Mallory using the CAST-BIZ program?
Yes, but I should clarify. One of them I'm pretty familiar with. I believe it's State Exhibit 48 that was used for the grand jury. The others I had never seen until I believe it was last week. So I'm probably gonna have to look at those if you're gonna ask me questions on those. But State's 48, I'm pretty.
I want to ask you a question about that. I'll ask you some other questions about the records we received last week. I'm going to have you handed what was admitted last week as States are, just my copy of it so that we know what we're talking about here.
Okay.
I'm curious about what was needed to go into CAST-BIZ to create that.
So when I open the CAST-BIZ program, I have to input what I'm going to refer to as source data. So let me define source data is any data that is in electronic format, typically a text file, that the CAST-BIZ program is going to link to this mapping session and use that source data to create the images we're seeing. I can tell you right off the bat, without a doubt, this one is linked to two different source data. One is going to be a set of CDR records, so the regular AT&T CDRs. And then this particular exhibit would require the regional AT&T tower list, which is a text file that contains all of the cell site locations, most likely be Western Washington, Idaho, and Eastern Washington, Idaho, and Western Montana is typically that region. But there's no way this map was created without the AT&T tower list. It's physically impossible.
Is the AT&T tower list, was that contained in the call detail records that were obtained by search warrant relating to Mr. Kohberger?
It was not.
All right. And in the CASVIZ program, when you input the CDR call detail records and you input the tower list, does that program create any type of log?
It does, and I want to make the record really clear on what I'm testifying to, because it can get kind of confusing when we start talking about different versions. The CASVIZ program offers two styles of mapping. I can just default to a normal size, what they're going to refer to as a wedge shape, which is representing the sector the device connected to. If I was doing that, all I need is the AT&T records, because the AT&T CDRs actually have the tower information that's required for that mapping. As soon as I change that feature, though, to add coverage areas, the estimated coverage areas, and now these little wedge shapes or these sectors are all different sizes, the CAS program has to be linked to a tower list that has location of all of those towers. That's the only way the program knows how to size the cell sites. So I just want to clarify, if I'm mapping the CDRs without coverage areas, all I need is the CDRs. If I'm mapping the coverage areas in the CASVIZ program, I have to have a tower list. This one, I can see 3 different sectors. 2 of them, if anybody sees this exhibit, just to make the record really clear, they're really hard to see. One of them is just under the N as in Nora, under the word Pullman. The other one is right by the L in Pullman. But they're different sizes. And that tells me right off the bat that the AT&T tower list is used.
And why are they different sizes? Mind me again, please.
Cell tower density, we see a great big sector right in the middle of this map, and I'm not familiar with the area here. It's basically south of Pullman and south of Moscow, kind of out in the middle of nowhere. Not a lot of cell towers out there, so one tower covers a very large area. Then the other 2 are going to be in Pullman. It's kind of hard to see on this map, but I believe they are going to be ones that are on Washington State University campus. A lot more cell towers, the coverage is much smaller. So it's just a way to look at tower density to kind of estimate how far certain towers may connect to a phone where others may have a very short range.
And is it based on that difference in towers that causes you to know that a certain type of tower report was used?
Yeah, it is a basic algorithm that uses tower density, and the only way to determine tower density is to have a list that has all of the towers, not just the ones that were used by the cell phone.
Okay. Do we have the list of the tower list that was used by Detective Mallory in developing that exhibit?
Detective Mallory stated he did not use a tower list to create this exhibit, so no, but I'm not sure how to answer that other than I haven't seen one.
Should it be there?
It is physically impossible to create this map without it.
If you had the logs from the CASVIZ program, would that give you more information about what was used?
It would. We would need the CASVIZ program as well. The logs are saving certain settings, and it's a JSON format, which is just a software language. We could load that JSON file into the CASVIZ program, and for the most part, we could replicate exactly what was done.
If I understand that, to turn it around, in order to replicate that and to see what was done, you would need a CASVIZ program. Is that right?
Correct, and preferably the same version that was used.
And you'd need a JSON file that was made by Detective Mallory. Is that right?
Correct, and depending on where this software program is, we would probably need the source data again because it may not be automatically linked. Anybody who did PowerPoint 10 years ago, you make a PowerPoint on one computer, you save it on a thumb drive, you go to a different computer, all the links are broken. It could create a situation like that. So you probably need the original source data as well, just to be sure.
What's the original source data?
In this case, it would be the AT&T CDRs and the cell tower, the regional cell tower list.
From that time?
Correct.
Okay.
Well, no, if we're trying to recreate this work, this is where it gets a little bit complex, we would need the exact AT&T tower list that Maori used but didn't use, which makes it really difficult because AT&T updates these on a fairly regular basis. If he used a November list and I use an April list, the results could be different.
Why would the results be different and given the month of the day?
AT&T could have added or subtracted cell sites in the area, which would change the tower density. They could also reconfigure those cell sites, so maybe they point different directions. Given the rural area, 2 or 3 months, I don't think you're going to see much of a change, but it's always possible. So if we're talking about recreating this exhibit exactly the way it was, we would need not just the regional tower list, we would need to know which version of the regional tower list he used.
Is that generally why people in your field save their work?
We're talking best practices 101. We're creating a work product that is going to be used in a forensic nature, not showing how an extraction is done, not showing the source data that I use to create an exhibit. It happens, but for the most part, it's not perfect, especially somebody who is a subject matter expert in digital forensics. I won't say I haven't seen it, but it is rare.
Thank you. Let's move on and talk about the cast draft. Have you?
I'm sorry, Ms. Bailey. The CAST report.
Draft. Have you?
Can I ask how much longer on this? Because we're 90 minutes. I need to give the court reporter a break. But if you're going to finish, in 5 or 10 minutes, that's probably fine.
Your Honor, I would say we probably have 15 or 20 minutes or so. If the court wants to do a break, we can, or
Yeah, let's take a recess. We'll be back in 10 minutes. Thank you. Relax.
Good afternoon, everyone. Scott Reich here, watching the hearing as it relates to Bryan Kohberger. This is on the motion to compel, specifically the cell phone tower data that is at issue. The defense has asked for basically all of the records that the governmental agencies, the FBI, relied upon to do their cell phone analysis so that government defense can try to recreate it and test its accuracy. What the witness, Mr. Syre, is talking about is a particular exhibit that they've admitted. It's been referred to as State's Exhibit R. And in that particular exhibit, apparently is showing, allegedly, where Mr. Kohberger was. And apparently this exhibit shows data, or it could not have been created without a certain amount of data that would have been provided by AT&T or somebody at some point, but has not been provided to the defense. And so the defense is saying you could not have created this exhibit without, for example, the cell phone tower density information. So where is it? Well, why didn't you save it? As you may recall, there was a hearing last week where Detective Mowry testified as to what he received from AT&T, what he did with it, what he didn't do with it. He's kind of their, the guy that collects all the data and processes it through. And this is what expert witnesses are for. Attorneys, I know, hard to believe, can't be experts in everything, right? So you hire experts, and experts will tell you, I need this. You need to ask for this. Happens all the time. And in this particular case, the expert's saying, I need this information because we want to be able to test it and to recreate it. And we need this data. Why don't we have it? The prosecution has basically said in previous hearings that you've got what we've got. Now, as a general rule, right, the defense is entitled to get everything that the prosecution has or has relied upon. The government cannot then go and destroy evidence or not save it. What could be the potential remedy for that? Now, I think it's an extreme case, and I don't think it would happen here based upon what I've seen thus far. But the judge could say, hey, if you can't produce this particular information, guess what? You can't use it at trial. Or I'm not going to let you have an expert witness testify to it. It's basically they're setting up a great house motion, which is basically that there is some sort of destruction of exculpatory evidence. Now you have to show that it was willful, that it was in fact exculpatory, but that's what they're trying to do. And Taylor, as I've mentioned before, I'm telling you, she's good. She shows up prepared. She shows up ready to go. And the last couple of hearings, the prosecutors have looked like they had their trousers pulled down around their ankles. They look pretty silly. And that's, I'm not, we'll see what the prosecution does on their cross. But as a general rule, they have to turn it over. Now, let me tell you a little situation that happened years and years ago. And, their witness was Mr. Ray was talking about this CAS-D system and how they can get all this data. And there's a big machine and they have all sorts of resources that basically everybody may not know about. Okay. Years ago, when they would ping people's phones, it was just kind of starting out. The FBI had this thing called Stingray. And basically it would kind of track your phone. And it would send out, and I'm probably simplifying this, I'm probably messing it up, but it would basically simplify, it would send out a signal and spoof your phone into thinking it was near a tower and they could use it to find your location. And at first people were like, wow, that's amazing how they can do all that. And then the defense attorney started saying, hey, turn that stuff over to me. I want to know how you did that. And the FBI would rather dismiss cases than turn over that particular information. Now, I'm not saying that maybe somebody used some high-speed, low-drag technical stuff that maybe, when they were looking for these people that the FBI has access to that they don't want everybody else to know about. And maybe that's how they did it. And maybe that's how we have that, but we don't, we're not going to tell everybody else we have that because I know that people will know, So I don't know. We'll have to wait and see. I'm a firm believer. I mean, I'm going to say when I was a prosecutor, my boss said, you give the defense whatever they want and we're still going to convict your guy. And if it helps the defense, so be it. Who wants to convict an innocent person by not turning over any information? That's just wrong. Hopefully no prosecutor would want to do that. And as defense goes, you want the stuff and you shouldn't have to go asking for it. Obviously, we got to a hearing at this point because the defense has asked for it repeatedly in their motions to compel, and the judge says, let's have a hearing. Prosecutions kept saying, you have everything we have. We've turned everything over. Nothing fishy going on here. This guy, Cy Ray, I know some people say he's maybe challenged when it comes to some things. Some judges, I think, have somebody mentioned in the comments, I'm not familiar with that particular case where the judge did not allow his testimony. I don't know what the circumstances of that are, whether that's even true, but I'll take them at their word. But he seems to be coming across as, a very knowledgeable person. He knows what he's looking for. He knows that this Exhibit R that the government has relied upon in their various search warrants and their arrest affidavits, apparently, that this is, they're trying to show this data, but they're also showing that you could not create this map without requesting, for example, the call data records, the regional tower lists, the call tower density, basically what was the strength of these signals. And that's where it really gets interesting is when, you can put on a map and say, this is getting really simplified here, but they'll say that, this is the area. Let me see if I can put this up, and that there is a, cell phone tower. and the signal goes out, a beam, right? They put it up in the tower. It's on thirds. You got a third here, and a third here, and it covers this big circle. And they can say, well, it's on tower, it's on this corner, and we think it was pinging to that one. But then you get into all the scientists guys that they're like, well, we think that's like this magic perfect stream that goes out as it relates to these cell phone tower signals. Well, they're not, right? You've all, driving down the road and suddenly, whoop, your phone drops. Kind of like me yesterday when I was watching the closing arguments in the Kohberger case, and all of a sudden I got too far out and cell phone signal wasn't strong enough for the Wi-Fi. Boom, kicks me off. Well, it's the same thing, but it also has to do with when you have mountains, and they can calculate all this to say, well, if the mountain's here and the density of the signal is this strength, you maybe get coverage down in the valley, but you wouldn't get it over here because it's also obstructed. It really is quite amazing. But when they go to court, they try to make it sound like there's this perfect signal that goes out, and therefore you can say, well, this is where somebody was. Well, you really can't get super. I mean, they're going to tell you you're in the vicinity, and that's what they'll tell you, is say, well, you are in a vicinity within this ring, but I can't exactly tell you where it is unless, of course, you have the phone, which means they can get the GPS data. There may be other things, corroborate that as well. But cell phone tower data gives you a general location where somebody is. They can't tell you exactly where they are based upon that. GPS is a little more accurate, but I'm not going to lie, it's pretty good. I mean, they can usually calculate it, but that is why, as a defense attorney, you get cell phone data stuff. You normally have to get an expert, particularly if it's not good for you, because you need to kind of cover your butt, so to speak, to say we looked at it and we consulted an expert, and the expert confirmed what the prosecution said, or they didn't. I mean, we have a very interesting issue that'll be going up on appeal here very soon as it relates to cell phone searches, right? The Fourth Amendment prohibits the general searches. You can't go in and rummage around and say, we are going to look through your house or your phone where you have an expectation of privacy without a warrant. And we're not going to tell you what we're looking for, but we'll know it when we see it. Well, and this issue's kind of about, and I've been litigating this hard, is that on cell phone searches, it is a general search. The technology does not exist for them to limit what they're supposedly looking for. When they plug in the phone, and I've got this testimony under oath from a guy that's been dumping cell phones for the last 22 years. You ask him, all right, you got the warrant in one hand, you got the phone in the other. All right, what do you do with that warrant? Well, I look to confirm, make sure it's the same serial number on the phone. Okay. What do you do as it relates to the date restrictions that you're limited to by the warrant? Nothing. I don't look at that. Why would you disregard the court's order? Well, technology doesn't exist. So they then have to dump all the contents from the phone because the technology doesn't exist to limit the date parameters. So they dump the entire phone. They put it on a drive. They then give it to the detective and say, here's the phone. Good hunting. Go in there. Look what you're looking for. A rummage. You may not know exactly what you're looking for, and you should, find it, right? That's a search, general search. And I think I almost got enough on a interlocutory appeal for the Supreme Court to look at it here, but didn't get enough votes for them to take it up. So, after appeal, they will. But, and that's the scary thing about this. I mean, whether it's a search of a cell phone, they get everything and they go look through it. And then they say, well, here's what we find is relevant. Okay, but you look through the whole phone. You can't do it like normally if you're searching where like, I know that I'm looking for a particular document, right? Even on a subpoena, I just can't say, give me all of the records during this time period. For me not to have a motion to quash filed on a subpoena for a document, subpoena ducis tecum, I need to be able to identify what document it is, why it's there, why I can't get it by any other means, and I have to be very exact. I can't go on the proverbial fishing expedition. And, I, there's been cases where cops will say, we want to know everyone that searched. There was a case here in Colorado, to be exact. They said, we want to know anyone who searched the search terms, and it was related to a house fire where several people died. And they sent the request off to Google, and Google sent all the information back as to the various IP addresses. And then they went to the IP addresses and they did this. It's a general search. The Colorado Supreme Court said, it's a general search. But since we hadn't really provided you any guidance on it, it's okay this time, but don't do it again. And so that is, I think, scary, right? I mean, think about it. You look at something on, a crime goes down and you read the news article. Suddenly, are you a suspect because you read the news? You read the news. You maybe did a subsequent search on it. Scary stuff, and that's what they do. And there's federal legislation passed that these companies have to turn this information over to law enforcement, but you go try and get it on your own. Very, very difficult, if not impossible. They can send a request, an administrative subpoena saying, give me everything on this particular account during, this general time period. And they'll send them everything. Here you go. I subpoena Facebook. I subpoena Instagram or something along those lines. They're like, hey, sorry, we don't keep those records for you. You need to go to the person. All right, we're back on the Kohberger motions hearing, and we're trying to decide the motion to compel as it relates to cell phone records that the defense is saying has not been turned over in its entirety, and the government has relied upon that. We had to take a quick break for a comfort break for the court reporter. So here we go.
Yeah, sorry. All right. Good?
All right. Or not. I guess
Not on the record yet.
moment. Oh, he's talking, but I can't hear anything.
Not on the record. Okay, we are back on record. This is State versus Kohberger, CR 2922-2805. Everybody I identified previously are still here in the courtroom. Mr. Cy Ray is testifying. We are still on direct. Ms. Taylor, go ahead.
Thank you, Your Honor. Mr. Ray, when we left off at our break, I was about to talk to you about the CAS draft report.
Okay.
So we'll start there. Have you reviewed a CAS draft report in Mr. Kohberger's case?
I have.
And from your review of that report, can you tell what records were relied on by Agent Balance to create that report?
That report would include, he had to have the AT&T CDRs, the full 6 months, a tower list to make some conversions that I'm seeing on the report, and also drive test data, which would be another form of source data, and then a mapping platform to ingest the drive test data into to analyze it to create these shapes that are then put into the draft report.
Okay, I think I have that. Do we have the same call detail records that Nick Balance used to create his draft report?
Yes, well, I believe so.
Do those records appear to come from the December 23rd, 2022 to AT&T warrants?
I would say primarily the second warrant from what I've reviewed.
And is that because the CAST draft report spans the full 6 months of those records?
That is correct.
Okay, and those records, did those come from the second AT&T search warrant?
That is also correct.
Can you tell anything about the tower report or how the tower information was used by Agent Nick Balance?
The tower identifiers that are predominantly used, not exclusively, but predominantly used in the CAS draft report did not come from the report AU. If there's a conversion that can be made, and someone would have to have the national AT&T tower list, or at least the regional list. And I would take information from the CDRs. I would look at certain columns in this AT&T tower list, and I could get certain identifiers that are now being populated to the CAS report, if that makes sense.
Do we have a copy of the tower list that you believe was used?
We recently received 4 different versions. And when I say versions, they're just by month. And I believe we have August, September, November, and maybe December, or maybe it's in October. I'd have to go back and look. So far, I've only had time to look at the November. And from what I can tell, all of that appears to be accurate.
Would we need the October or the missing month to be able to do our work accurately?
It's a really good practice. I'm sure that's why the FBI included it. If I'm mapping records over a long period of time, like in this case, 6 months, I do want to see the different versions of the tower list to make sure that if a change was made within the network during that 6-month period, a tower I map in July may map differently in November. So it is important to have that data.
We have 4 of the 6 months, but not the other 2.
Correct. It would be helpful to even maybe see May, because there may not have been an update made in late June, early July. So May's would be what I would start with.
Can you tell if drive testing was done to create that cast draft?
Yes, there's images in the latter part of the report up around slides 100 and above. I believe there's a total of 4 images that were populated to that report that would require drive testing.
When somebody's doing drive testing, do you expect data to be produced?
Absolutely. Creating a work product that uses drive testing and then coming into court and testifying without the drive testing is no different than creating an exhibit like this and then saying, well, we don't have to produce the AT&T records that created this. The source data for drive testing is the drive test.
Do we have the drive testing that was done by the FBI to help create that report?
We have what I believe is the majority. There are some significant pieces missing. I can't say that those missing pieces exist and haven't been turned over, or they were erroneously not collected. I don't know which, but there are some pretty significant pieces that are missing.
I'm going to ask you some questions about that. But first, I want to know when you first saw drive testing data that was produced to us in Discovery. What did that cover?
I found a file in the Discovery, I want to say early December, that included drive test, but it was about a 3-minute sample that covered less than a quarter of a mile in a completely irrelevant location. So it added no value to my analysis at all.
What were you looking for? What time frame and location were you looking for based on the CAS draft report review?
I would expect significant drive testing around any location that coverage maps were being used in the CAS report. I would expect significant documentation on potential routes that this device may have taken. I would expect significant documentation on the crime scene.
You just told us that you think we have most of it, but there's some significant parts that are missing.
Yeah, and I want to qualify that just so it's really clear, because I understand it's starting to get very technical. There's over 500,000 lines of data that was turned over. So I'll make it clear, there's a lot of data that has been produced. I would say, in my opinion, looking at what's been produced, probably 2 or 3% is missing, but it's not the amount of data or the time of the data, it's the locations of the data. Some of the most significant locations in this case we're missing some data.
Those significant locations, have they been depicted or captured on the CAS draft report?
They have.
And tell me what those locations are. What are we missing?
I am unable to find any measurements along, I believe it's 270, the Moscow-Pullman Road. If you drove the most direct route from Pullman to Moscow or vice versa, pretty much as soon as you're leaving Pullman to the time that you arrive in Moscow, we are missing that entire stretch. And if there's ever been a case that we need to look at What does it look like when a phone travels from Pullman to Moscow? This is probably the case. We have the neighborhood around the crime scene, but we don't have the crime scene. Normally, that wouldn't be too terribly significant because if it's a flat area, there's not a lot of vegetation or mountains. You could probably interpret the same. The location of this crime scene is very unique because it sits on a mountain. Part of it is shielded by a mountain. There's a lot of other big, thick, dense apartment buildings there. Your phone is going to behave differently inside of that residence than it might on the road behind the residence or in front of the residence. I can't find any drive test data that actually encapsulates any part of the property.
You talked about the device that helps do the drive testing or that captures the data while you're doing the drive test. What's that called again?
It's a drive test scanner. The most common one used in law enforcement is created by Road and Schwartz, that same company I referred to earlier. I'm familiar with the hardware that the FBI uses, and it is a Road and Schwartz scanner.
Is it called Gladiator?
Gladiator is the company that sells the product to the FBI. Gladiator actually buys this product from Road and Schwartz, and it does what they call white labeling. So they buy the hardware from Road Schwartz and they kind of slap their sticker on it and they put their software in it and then they sell it to the FBI. But ultimately it is a Road and Schwartz piece of hardware.
And once you have that piece of hardware, once you have this device, does it just work forever or is there anything that has to be done to make sure it's working properly?
It is a technical piece of equipment that takes measurements. It is required to be calibrated. The best way that for probably everybody in the courtroom to think of, if we know a little old school, is the old breath test. If you had a DUI and law enforcement couldn't produce the calibration records of the breath test, it was really problematic. Similar thing here. We want to see that the device is calibrated. In this case, it's really important because, keep in mind, I reviewed thousands of these drive tests over my career. There is a significant gap that I believe there's something malfunctioning in the equipment or the operators are just not paying attention. I can't tell you which one it is. So in this case, the calibration records to show that that device is functioning properly are really critical.
Do we have those calibration records on the device that was there more than one device used?
There was actually 2 devices used.
And was this drive test done on just one day? Is this a one-time shot?
No, I think there's maybe 5 days total that I've seen drive test data collected.
Okay. So now let's talk about the calibration for this instrument or this machine. Did we get records for all the machines that were used by the FBI in this case?
We got the calibration records that were taken prior to the use of these of the samples. It'd be really helpful to have the calibration records after the use. So we kind of need to bookend those because we know that it left Road Schwartz factory in October and everything was working great. When it came back, we don't know when it came back and we don't know if it was functioning properly when it came back. It's not uncommon for there to be errors. If I saw a report and it said it came in and it had 2 errors, it's not the end of the world. The sky doesn't fall. You have to get into the documentation to see what those errors were. Normally, the device kind of self-calibrates itself. If you know what you're looking at, the major concerns that you would see when calibration is off, it becomes very obvious because results are really flawed. That's where I have a concern in this case is we have what I consider a significant chunk of data for specifically a location where the instrument is running. There's no doubt it's functioning, but it's not properly collecting AT&T data, which is concerning as to why.
Because there were multiple drive tests done, and you talked about bookending these calibration reports, would you need to bookend all of the time that the drive testing was done with these calibration reports? And what I'm saying is if there's something done in November and then drive testing done in December and then more drive testing done in January and then maybe some in March, do you need the bookend calibration reports around each of those drive tests?
You would. To date, I haven't seen any drive test data, I believe, beyond January Yeah, and I'm not sure the time zone, so maybe it could creep into January 6th, but if there's any drive test data after the first week of January, I'm unaware of.
Okay. So in our case, which months are we missing?
For the calibration,
Yes.
whatever the next calibration, the FBI would choose when to send these devices in. So whenever that next calibration report was generated for these two devices.
On the calibration certificates we have, I think you told us that after the maintenance, it went back into service and passed inspection, was functioning properly.
But when it came in, it didn't have multiple errors, but when it went out, it was functioning properly.
Is that why you need to see the next one on the other side of the drive testing?
That is correct.
Okay. Now, when we're thinking about the data that, the drive test data that we have that's missing some significant portions, could it be because the machine wasn't working right all the time they tried to do drive testing?
Yes.
Okay. Is it also possible that the FBI agents using this machine weren't properly trained to do the drive test data or to do the drive testing and collect data?
I know of the two FBI agents from prior lives. I believe they're properly trained.
So we're looking at either the machine itself isn't functioning properly, or could that data have been pulled out of what we got?
If we're talking about possible scenarios that would cause the shortcoming of data, maybe it was never captured in the first place. I can't speak to that. The machine erroring, at least during one portion of this drive test, I've seen similar errors before. I'm pretty sure they had a small period of time where it had been a very busy day and it kind of gave up for a little while, like any computer will, and it needed to be reset. Could things be extracted and us not know? That's always possible. I can't rule that out.
Is the missing data important to you to fulfill your duties in Mr. Kohberger's case?
I don't recall when I got involved in this case on the day where I could actually start looking at evidence. I've had a concern since the very first day I saw the cast draft report that there are significant errors in the drive testing. It was before I even saw the drive testing. I can look at the coverage areas and I can tell you they're wrong. So yes, it's not a concern that they're wrong. People make mistakes. We can fix things. It's a concern that I still don't have the source data that any expert, not just myself, but anybody could sit down and look at and say, okay, I see what's happening here. Here's how we fix this. Unfortunately, that mistake has a ripple effect, and I'm seeing multiple errors that are happening as a result. So that's why this data is important, is we've reached a point that we need to determine, is this just human error? Is this accidental? Is it intentional? Is there other things at play here that's changing this narrative to where there's clearly some manipulation of the original data?
And having that data, will that help us answer that question?
It's the only way we're going to answer that question.
All right, I have just a couple of other questions for you, and I'm going to depart the cast report and the drive test data a little bit, except as an investigator or as a person doing an analysis of this case, does the drive test data tell you where a phone traveled to indicate other investigation that you should do?
Technically, the call detail records tell us that. The drive test data help us become more accurate with that. AT&T is one of the best companies in this particular situation to show device movement because we get a constant connection. So when, and I will emphasize, when all of the data is mapped, and I'm talking about the CDRs, we can get a really good idea. Hey, a phone traveled north for 10 miles and then it traveled east. The drive test data would actually allow us to replicate and recreate these tower handoffs that we're seeing to come up with that first theory to now we can say, in order to do this and hit these towers in the sequence that it did, it has to be driving on this highway. And then when it went east, it most likely turned onto this highway. So the drive test data helps us get very specific with what the CDRs mean.
As an investigator in performing an analysis work done in this case, when you have the CDRs, the call detail records that tell you where a phone's been, is that useful in directing your investigation to what other evidence might be out there, like videotapes?
Qualify my answer to it because I'm not sure if you're asking specifically for this case or in general. Yes, you map all of the data. And especially if you're going to justify 6 months worth of data on somebody's cell phone, you map every single connection that there is in those records. From what I have reviewed, the FBI mapped 6% of the data that came in. Mallory's testimony and what I've seen through here, he was up to about 18%. So by either standard, more than 80% on both accounts were never mapped or accounted for. And I'm not talking overall from every single day for 6 months. I'm talking about the timeframes that are chosen. So for example, this time period that's represented here is where I'm getting the 18%.
And that's the 48 hours.
This is specifically from 2 a.m. to 6 a.m. on the morning of the 13th, arguably the most critical time period of this entire investigation. They mapped a handful of connections. When I say a handful, they mapped 18%. When you add the other 82%, it tells a much more detailed story. When we put the drive test data on top of that, you can get even more refined. But to answer your question on any case, that's this case, on any case, and we teach best practices. We've established best practices going back to 2008 in law enforcement of what you do with this type of data. It is a terrible practice to justify probable cause for this very detailed call detail records that give breadcrumb-like trails for individuals and then not map it. We justify an entire probable cause statement saying we have to have this. Not mapping it and then making decisions and work products with leaving that out is extremely problematic.
Last week, we received some additional records that Detective Mowry found when he was preparing for his testimony on this mission to help. Have you had a chance to review those records?
I have. A couple of them are very technical, so I'm not going to say that I've mastered them yet, but I have a good idea of what was provided and what it means.
Based on your, I guess, not as thorough as you'll do review of these records, do you have a sense as to whether these records matter to us and what we're doing to defend Mr. Kohberger?
Given the timing of these records, from what I can tell in the emails that were produced by Detective Mowry, these records were generated on the 23rd of December. It's when everything starts with probable cause statements. If I had to pick a time when the wheels fell off the wagon, that's the date. There are statements and there's assumptions made in the records that will never be supported by the data. There's a lot of claims that are said in these emails, and even the name files of the records are problematic. It does not represent what it's claimed to represent.
Sounds like those might be pretty important to us defending Mr. Kohberger.
I could give examples, but I know it's a very technical thing, so I'm not, it could be extremely impactful to either side. I'm not saying just in defending Mr. Kohberger, it could be extremely impactful in prosecuting Mr. Kohberger. The problem's the problem, not what the data helps or hurts.
The content of the data, though, is it helpful to us in representing Mr. Kohberger?
It absolutely is helpful. Everything that I've seen to date is concerning to me because it's exculpatory. And I need to clarify this. When all of the records are produced and the dust settles and I have time to review it, I reserve the right to say, no, now I'm seeing everything. Here's what I'm seeing. Because of the piecemealing of the data, because of the missing data, because of data that I'm reviewing that is incredibly inaccurate, everything that is missing is absolutely in the benefit of the defense right now. There's other reports that I believe are missing that I can't tell you are in the benefit of Mr. Kohberger or in the benefit of the state. If I was contacted on December 1st by Moscow Police Department, there are things I would have absolutely said, you get this today. Do not hesitate, and especially come December 23rd. Not because of who it's helpful for, but because those documents are the only things we're going to get that's going to be able to allow us to interpret what it really means. When we don't get those documents and we piecemeal things, it creates this narrative that is very harmful for the defense's case. As I've got more documents, I'm finding it's not harmful for the defense's case. There's a lot of misstatements that have been made. So yes, to your question, to date, it is very helpful for Mr. Kohberger. I reserve the right to change that opinion in 6 months, depending on what type of documents are released and what's out there.
Fair enough. I need just a minute, but I don't think I have any other questions.
Thank you.
Mr. Ray, thank you. I don't have any other questions right now, but hold on. The prosecutor might.
All right. Ms. Taylor, Ms. Jennings.
No, no, we don't have any questions at this time.
All right, may this witness be excused.
He may, Your Honor. Thank you.
All right, Mr. Ray, you're free to stay, you're free to leave if you like. Sure. Thank you. Another witness?
Your Honor, we do not have any other witnesses. We have argument for the court.
Okay. Let's go ahead then.
Your Honor, what I'd like to do is I'd like to start with Ms. NASA. She's going to cover one of the requests specific to the grand jury subpoenas, and then I'll cover the rest of this morning's argument.
Okay, thank you.
Your Honor, to facilitate this argument on this point, I am going to hand you defense exhibits A and B that were submitted in our records for today. I want you to be able to look at them while I'm talking.
Okay, thank you.
As of today, there have been at least 50 federal grand jury subpoenas that have been issued in this case. Exhibits A and exhibits B are an example of copies of grand jury subpoenas that we have received out of those more than 50. And what I didn't provide to you that goes behind that what we got with those is the subpoenas include attachment A, which explains what is being subpoenaed. And then what has been produced is the responses to those subpoenas. And in some of the subpoenas, we also have the certification by the person who has produced the records in response to the subpoena. Some of them are missing. We have asked the state to produce all of the subpoenas, and their response is that they are not in possession and control of those subpoenas, and they do not intend to use the subpoenas as an exhibit. And we have not justified why we need those subpoenas. And for those reasons, they are not going to produce them. I'd like to begin by saying that as it relates to any argument that the state is not in possession and control, rather than beat the dead horse on that issue, Idaho Supreme Court came down in 2023 and made it crystal clear that anybody that's acting on behalf of as an agent of the state puts those records in the hands of the state, and they need to produce them. State versus Pendleton, 2003. The other thing is that in terms of the state arguing that they are not going to use a subpoena as an exhibit, that is not in and of itself a defense to not produce a document to us. We have a million reasons why we need to look at documents. We understand that out of the 51 terabytes that have been produced, that not all of that is evidence that's going to be coming for the court or the jury, but it doesn't mean that they aren't material or exculpatory. The subpoenas, based on reviewing the records, are in the hands of basically three agents. There is an FBI forensic agent by the name of forensic accountant, Michael Douglas. There's a special agent, Travis Shirley, and there is another agent, Mary Tyndall. These are the three agents that are receiving the subpoenas, reaching out to the providers that they're serving and asking for the documents. For the court to understand why we need these documents, I want to tell you what we're doing with discovery and timelines. There are more than 100 search warrants in this case. There are more than 50 grand jury subpoenas in this case. You've heard all kinds of information about the probable cause affidavit and the timing of that. Timing in this case for the defense is everything. So we are creating timelines that put in the dates of affidavits of warrants, the information that's received, and the date that it's produced. With subpoenas, when we don't get a copy of the subpoena and all we get is the warrant or is the subpoena return, we don't know the scope of what the state has asked for. We don't know the date that the subpoena was served. And in some of them, we don't know that there is a certified return. So we can't take our timeline on warrants and our timeline on the probable cause affidavit and our timeline on everything else that we're putting in there and interlay the subpoena information that the state is getting. And we are desperate to find out the timeline in this case and when the state knew what and when. There's no question that motions to suppress are coming. Motions to suppress are coming on warrants. And whether or not those motions to suppress are based on Frank's material because misrepresentations are made depends on the timeline. So if there's a representation made in a warrant that things happened in a certain way, if we are able to look at the timeline and say, we know that the state knew this when, that gives us an answer on whether or not the suppression issue includes a truthful statement in the affidavit. And if I'm not making sense, I want you to tell me to clarify that. But we need to know the timeline of all of the evidence in this case and when the state knew what it knew, or why certain things were being looked at before Mr. Kohberger's arrest or well into late in the year in 2023 related to the victims, and try to piece together, is that something that the state is still seeking because they're pursuing the alternate suspects that exist in this case? There's so many things that we're trying to understand. So what we're asking you to do is enter an order compelling them to produce the subpoenas. You see that they had at least two in their possession that they possess, and it will clarify it for us. And we will be able to create our timeline and put all of these things together and know when and why the state was doing these things. And just to add one other component, you know, you're hearing about cell phone records and cell phone records today being produced on warrants. Well, there were several sets of cell phone records that were produced pursuant to a grand jury subpoena. Still not clear to us why warrant versus subpoena, and they're different providers. And some of it's for phone numbers that we have to figure out who those phone numbers are. But all of this information is critical and material for us to be able to do the case, to do our work in this case. So I would ask that you enter an order to compel, and that way the state has the ability to take that to the FBI agents and say, the court has entered an order, we've got to produce the subpoenas, and we'll get the subpoenas. And to the extent that the state may stand up and say, you know, we've got this TUI demands, we've got to deal with TUI. I just want to make it really clear for the court that TUI's not an obstacle. TUI's a hoop to jump through. The code related to 28 CFR 16.21 specifically states that the purpose of TUI is not to prevent federal agents from giving states discovery in a criminal case. Purpose of TUI is because these federal departments want to know when certain records are leaving their files. Understandable, but it's not meant to keep us from getting records that we need in this case.
Thank you. Response?
Well, simply put, we can't give over what we don't have. And we do not have the majority of these subpoenas. What we do have, we've turned over. I reached out to the U.S. Attorney's Office. They advised they're not going to provide
What, why?
because they don't provide subpoenas. You know, just like most grand jury material, it's sealed and not typically provided. But
Not typically,
not provided.
but even with a TUI letter, that wouldn't give it. We provide, they wouldn't follow that.
We have not, I'm not sure. But beyond that though, even if they were to provide it, I still don't understand how this moves the needle one way or the other. You can tell, I've detailed, there's 71 federal grand jury subpoenas. And in my response, I've detailed exactly what they were for and what records were received so that you can get the scope of what was requested from the actual records. The piece of paper that was given over saying, give us these records is all they're asking for, but they have the records. They have the important part of this.
So they have the timing based on the subpoenas
Off of
that
the
you've
records,
provided to the defense.
off of the records provided. You can tell the scope as well as what they're for. And I've detailed exactly what they were for and the scope in my response.
Any response?
Judge, I wouldn't be wasting the court's time asking for this if the questions were answered based on the state's response to our request for discovery. Timing is critical on when a subpoena is served, what was the scope, then we can look at the documents to see if they are actually responsive to the scope. And knowing the timing of when that was served versus when it's produced to us is different. And again, I mentioned some of these things are pre-arrest of Mr. Kohberger, and some of it is in the middle, and some of it is, you know, frankly, months after the fact, if not a year after the fact, for where they're looking for things related to the victims.
So
And-
can I ask a question? Because Ms. Jennings just said that that the dates, well, all the subpoenas that were provided to you, 71 subpoenas, and those, each one of those had the scope of what the request was in the subpoena and that it would be dated. No,
That's not true.
that's not.
That's not true. No, there are all kinds of different records and different methods that the people that were the businesses and the people that were asked to produce the records produce them in different form. I do not know when they received the subpoena, the timing of it, and I do not know for all of these what was the scope of what was asked for versus what was produced. I do know what's produced, but I don't know the timing. And the answer of the date discovery provided, which is in Exhibit 1, that the date that a discovery is provided to us doesn't answer the first two questions that I have, which is the timing of when they asked for it and the scope that was stated in the subpoena of what they asked for. Some companies were asked probably for a certain number of months, and they didn't have records that were responsive to those number of months, right? Because when the state's doing this investigation, they're not necessarily knowing exactly what records exist. So being able to be specific is important. And I want to touch on this issue of it. It's not in their possession. I get that. But you have complete control over what evidence is going to be coming into this case with your orders. You make it crystal clear, produce it or it's not coming in. That's the first level of sanction. And then we can just get going from there. You know, something that's destroyed, you can't produce that. There's going to be a spoliation instruction. Something that we keep repeatedly asking for and it gets past time, we're going to knock the death penalty off the table. You know, you have control to get these issues that we're struggling with fixed by saying, this is my order, produce it, or there's going to be a sanction.
You may be overestimating my power.
I think
I can't
think you're
control everything.
underestimating your power.
Well, I have a good sense of where my power starts and ends. So I don't know. I mean, there's so much discovery that has been shared. Are all of these 71 subpoenas, have they been provided to me at this point? Because I don't think I've seen them.
No, they went through a federal grand jury. So this is, you know, we haven't seen anything in terms of the grand jury testimony transcripts. What I have surmised based on my federal practice, grand jury as an investigative tool because the FBI is partnering with them. That makes complete sense. These subpoenas are in the hands of the 3 agents that I gave you the names of. They haven't come through you. They're in the hands of the agents. And so it's a matter of them just gathering the records that those agents have in their possession and providing to us. You know, and it helps us create this timeline in a case where discovery is being given to us as if we're living in a snow globe and it's just swirling around us and we're constantly having to put it together. So, you know, you've asked us several times, what can I do to help you guys get your work done? This is one of those things. Let us see the subpoenas so we can overlay this in our timeline.
But you just want the subpoenas. You don't necessarily are going to get the response.
We have the responses. We have the records, but what the records don't tell us is what was in the subpoena. It's like a warrant return. What is a warrant based on? It's based on an affidavit.
So
Right.
this is what you want, the paper that says,
And the
this is
exhibit.
what we want.
And the exhibit A that's attached to that, which I didn't give you a copy of exhibit A, but exhibit A is attached to each one of those. And then it specifies to the company, you know, you're looking for phone numbers that are this, and this for these dates. You're
That
looking
doesn't have the date on that, when
in
it was served.
those subpoenas tell us, we know when they are served because it comes back with a date on it. And then,
Right.
and then the attachment A has the scope of what they've asked for. What we've gotten is the documents without, it's like not having the affidavit to the warrant return.
Okay. I think I understand that. And I'm going to go back to Ms. Jennings and just clarify. What have they been given already?
They have been given records in response to all 71 of those federal grand jury subpoenas.
Do they have dated on there? Because that's.
Many of them do. You can see that from the description of the conference that I provided
Yeah.
before. I can't say that all of them do, but many of them do.
Well, that's
So
very
what-
important, apparently, for the defense, as Ms. Mathis said, that timing is everything here. So I think that's what they're really after. That's one of the things they're after is just the time frame.
We can seek to inquire as to, because what I keep hearing is they need to know the date that these various companies received the subpoena. We can still inquire, it's provided on a lot of these,
Right.
but on the ones we're missing, we can attempt to inquire and find out the date that it was served, and we can still do that without providing the piece of paper.
Well, besides the timing, what's the relevance to this this scope that was requested? Yeah. You know,
What's the relevance? But
Yeah.
we're not relying on any of this.
I know, I don't think what do you think they think is relevant?
Yeah, for sure.
Okay. Mr. Thompson, so what is the relevance? But aside with the timing, okay, and the scope.
Judge, I'm not going to give you the specific date right now in open court on one of the subpoenas, but they used a subpoena to get one of the most critical pieces of evidence in this case. And they know that,
Okay,
and they are going to use that.
Respond.
it's something that I don't know about.
Well, I mean, you probably,
I've been.
you do know of it. It's in the probable cause affidavit.
Okay, thank you. All right, Ms. Jennings, you
What
want?
I can tell you is that for the majority of the stuff, we did state search warrants. And we've received many of these records that way.
Okay, thank you. All right, enough with that. Thank you very much. Appreciate it. Maybe it's a time to, well, let's see, where you still have your argument. How long do you think?
Your Honor, my intention is to talk about the law that governs discovery requests and ask you to compel certain things. I'm going to go through our fourth request. I'm going to tell you a few things that we have, and then I'm going to tell you why you ought to order that the state give us the rest of it, how it's material to us, and how it's in the possession of control of the state. I'm going to do something. I would say I'm going to talk 15 minutes, maybe.
Okay, great. Go ahead.
Thank you. Your Honor, then where I want to start is with Idaho Criminal Rule 16 that governs discovery. 16A directs which things are mandatory disclosures from the state. Those are things I don't even have to ask for. And those are items that the state has possession and control over that would tend to negate guilt or reduce punishment. 16B is the portion of the rule that governs when I request items in the course of my preparation of the case. And I would have the court keep in mind 16A and the prosecutor's responsibilities and Idaho Criminal Rule 16B and the discovery requests that we've made and what we have not received. We've asked for documents, we've asked for reports, we've asked for qualifications and summaries from experts, and we've asked for media that's been gathered in the case. The court can order other things that we ask for based on the need in the case. I would remind the court of the case that Ms. Massa just talked to the court about, State versus Pendleton. I know the court's familiar with this. This is a good case because it's recent and because it takes the time to define what's material and what's within the possession and control of the state. We need to think about our motion to compel in the order we are requesting from you in the context of what's in the possession and control of the state. Your Honor, the State versus Pendleton case says that any law enforcement, and this includes the prosecutor's office, it includes their staff, it includes any law enforcement that worked with them on the case. In this case, you're looking at Moscow Police Department, Idaho State Police Department, Idaho State Police Forensics Lab, and FBI agents, to name a few. So what those entities have and have developed are within the possession and control of the prosecutor. So with that backdrop, I want to run through our specific requests and talk about what we need. You've heard testimony, and so I think you know why these things are material, but let's go over it again. Starting with the fourth motion to compel, Ms. Massoff went over 1A, the grand jury subpoenas. I'm Gonna leave that argument alone. She did a fabulous job with that. When we're looking at 2A, this all comes from the defendant's 11th supplemental request for discovery. 2A is the video on King Street. Your Honor, we began asking for that a long time ago. We have it in full, so we don't have to talk about that. We received that full for all of the hours and days in question with both audio and video on 5/10. So we can mark 2A, item 219 off of our list.
219.
219.
And there, I've gone through pages and pages and pages, so I think I really appreciate you being very specific about, what you have now and what you will still.
Okay. Good, because it's the only way I can keep track of it.
Yeah, well, same here. Thank you.
You're welcome. Your Honor, item 2B in our fourth motion to compel is item 224. That's the CAS biz law. And this one is rough. The court heard last week Detective Mowry say, I don't have any of those, except I found these other items that we'll give you now, which were not Mowry's CAS biz laws. The hard part for us about this one, Judge, and I have to make a record. I think you can order them to double check, and I'm going to ask you to order them to double check. But the hard part of this for me is that on January 9th, we asked for these CAS biz logs. And the response was from the state was CAS biz does not produce logs. And that's just not true. It does. It's capable. It produces logs. You've heard that in the testimony. Then we filed our motion to compel and explained we have an expert. We know it produces logs. We're going to bring them. And the response was the working files were not saved. We received that response on April 23rd, 2024. And then on May 10th, we got a little bit more explanation about default settings were used and optional session files were not uploaded. This is really, really difficult because of the varying answers that we've received. The court's heard testimony from Mr. Ray about how important these logs are to know what was done. This is really challenging. We can't recreate what Detective Mowry, who testified before the grand jury, did, unless the court orders that we get the tower list he used and we have the CAS biz program. And quite frankly, that's what we want. We need to see how this work was done. This is important work. I'll tell you the other thing that's really troubling and frustrating, aside from the other files that we received in preparation for motion to compel, is these screenshots that we got for the first time last week when we're on a motion to compel and have a witness before the court. We didn't have those screenshots that Detective Mowry had created before. The only thing we had was Exhibit 48 that was given to the grand jury, which is a video that was handed over then. So this is really problematic to be told these varying things and then have something else produced on the day of testimony. Your Honor, we are going to request that the court order that we have the tower list used by Detective Mowry and access to the CAS biz program. So our expert, Mr. Cy Ray, can go through and see what Detective Mowry did. That it's imperative that we be allowed to do that. That's the only way to recreate what Detective Mowry did.
It seems to me he did acknowledge that he just went back and provided this a day or 2 days before he testified that he found this additional information. So I'm thinking that the state got that information and had provided that to you. Now, we also heard a lot of the quotes missing pieces today, which I'm guessing that FBI, Mr. Valance and Detective Mowry are going to go back through that and see if there's something else. At this point, I'm assuming that, some things may have fallen through the cracks. I mean, it is very complicated. There was a lot going on. we have some time before trial. I just hope that everybody goes through, their computers or their files or whatever they're going through so that it's complete. So, what I've been watching over the last 2 months is that, there have been, supplemental responses to the defense. So things were coming in. They were waiting for information to come in so that they could provide that to you. So that's why I don't want to go backwards either. I just want to make sure that we are addressing what you don't have and what actually you're entitled to. So that's the tower list. I mean, I don't know anything about tower lists, so I'm learning about that. I don't know that Detective Mowry addressed that, really. Maybe unless I missed that.
Your Honor, I believe he testified last week that he used the tower list that was contained in the AT&T record that he received. You heard today that that doesn't exist. And you heard today that the tower list was something different that he used. And that tower list had once that was entered, there was a selection on the program to do tower density as well with that.
Like I said, it's confusing.
It is, it definitely is.
We'll keep going on it.
Okay, thank you.
You want the tower list?
Yes, I think I'm getting there, but I definitely want that. I want the one that Mowry used to do his CAS Viz work back in May of last year. That's the one I really want right now, at least at this juncture in the documents right now. I do want to clear up though, when we talk about what Detective Mowry found last week when he was preparing to testify, those are emails between him and Nick Balance. Those are JSON files from Nick Balance to Detective Mowry. None of those things that he found, other than screenshots like the exhibit that you have of his map with the different size towers depicted, other than those screenshots, the other things he had came from Nick Balance. Those were not his logs that he found. Those were not his towers that he found, just to be sure that those are still missing to the extent they exist. And we can't recreate what he did without the list and program. Moving on.
Thank you.
Moving on then, Your Honor, is item 226. That's called the Hemisphere Program, also known as a timing advance report. Your Honor, this is one of the troubling areas again. The first response was that the records do not exist. There were letters exchanged between the state and us asking for more information. In one of the letters from the prosecutor, we were told that this program was not used in Bryan Kohberger's case. And then we filed a motion to compel. And we were told that the state was not in possession of the timing records. And then the next supplemental response in May of this year, just a couple of weeks ago, was to tell us that there's some new certified records from AT&T that we're going to get. I don't know what those are. I can tell you that these timing advanced reports were asked for from AT&T, from Verizon, from T-Mobile, and another cell phone company in both of the early AT&T warrants. We called them the 48-hour and then the extended warrants back on December 23rd, 2022. We don't have those. So I just want to make a record that I need to know what happened. Moving on then to 228, item 228. That was trying to understand what was relied upon for the second AT&T warrant. And we heard quite a bit today from Detective Payne about what he relied on for that second warrant. And that had to do with what was produced and analyzed in the first warrant. However, we asked for some emails and some communications. We know about some text messaging that we've received, but we don't have written correspondence, emailed correspondence, exchanging information, just the text messaging. So we want all of the email communication between Payne, and Balance. Well, between anybody from Moscow PD and anybody from the FBI. Your Honor, item 229 is the MAID data. I would say we received a disclosure, and I think we got that on either 510 or 517. And I'm gonna need some time to have an expert help me out with that. I don't know if that's complete. I also know that in the 5th motion to compel, there is information we've asked for from Babel. That was a program that was used to help decipher some of the MAID data, and we're going to talk about that in a minute, but that one's yet to come. So I'm going to ask the court for an order compelling the state to give me all the MAID data. They may have already complied, though. Their intents to comply, I can tell you that.
What does that stand for again?
Mobile advertiser, let's see, I've got it in here.
Okay, I'm glad.
Identification number, mobile advertiser identification number.
Okay, thank you.
You're welcome. All right, Judge, we are now talking about item 242, the CAST report. The history of this is we came to the court asking for the CAST report, knowing it was relied upon last year, and the court ordered that we receive it. We received one that was stamped draft all over it. You've heard testimony about that today from Mr. Ray, and it's not a final report, and we knew that when we got it. We asked for that. We asked for the analysis behind that, and we haven't received that. We were told on February 23rd of this year that the state will provide this by March 31st. Well, March 31st came and went, and we did not get it. So on April 23rd, the state said we still don't have it. And then on May the 10th, the state responded to this request and said that because we provided additional information, Mr. Kohberger's alibi, they need more time to do work on this CAST report, and they'll get it to us later. Your Honor, I think you ought to order that we get the CAST report, and I think you ought to order that we get everything that went into developing this, and we get the analysis that they made from that. This is particularly troubling. Their response, you told us something, so now we have to go reconfigure the CAST report. Let me tell you why that's troubling. Item 243 is our request. Give us a list of everything Nick Balance relied on when drafting his CAST report. And we were told Nick Balance relied on the call detail records from AT&T. Nick Balance relied upon tower records, and he relied upon the drive test data. Nowhere in there does it say, if you tell us anything about the case, we need that to rely on that too. These are records that exist. These are tower lists that exist. They go into a program. You do drive testing to understand how the device interacts with towers, and you create a report. So we're asking the court to order that we get the CAST draft report, we get the full list of everything he relied upon, and we get the analysis of what does this mean.
So another clarifying question, maybe. So I listened to the testimony today, and that it sounded like a CAST report was provided, but maybe it wasn't complete, is what Mr. Ray suggested. But I think that maybe I'm guessing, we're assuming that the state provided what they had, but it maybe they're still working on it. I don't know. But didn't you get initially what they had as they characterized as the CAST report? So when you say, I mean, we have problems with language, I think, especially when we're in this area, technology. And so we might be just going back and forth like this without really understanding what we're asking for or what we're providing.
Let me see if I can clear that up. The testimony today, when we had Detective Payne on the stand, when we talked about what did you rely on to get the second AT&T warrant, he said that there was something that Nick Valance produced and that the prosecutor had it, and he thought it was a cast draft.
Right.
And then you heard from Mr. Ray, who said, I've seen the cast draft report, and maybe it's something different that Detective Payne looked at. It wasn't this big, long cast draft. The cast draft report, and I'm calling it draft because it's stamped draft. I knew it wasn't final when I received it. We got that because you ordered that the state give that to us last summer, last July. So I had this draft. I knew it wasn't final. Ms. Jennings knew it wasn't final. We've talked about it. We believed that we were going to get the final report by March 31st. We don't have that yet. It's the final report that we need. You also heard from Mr. Ray talking about the things that are mistakes in the cast draft report. These reports go through a peer review process, and they can look a little different when they come back out on the other side. Usually not vastly different, but they go through their process. It's that final product that I need that. I need to know everything they relied on to do their work. I need to know what this draft report is going to look like. The court should know that when we get to trial, likely Agent Valance is going to come in and talk about his cast draft report. He's going to be an expert in the field and talk about what he found and why he found and what he relied on to do that. I'm going to come in with an expert that's going to explain what his work did. Now, if the work aligns and Nicholas Valance and our expert aligns, well, that's just going to be shorter. But right now, it's definitely not looking like that. It looks like they're going to have their side, and we're going to be talking about what the data shows. So what I want is the final report that we were told would be available by March 31st. I need time to work on it.
Sure.
What I want is a full list of what was used to create that report, what was relied on. I have to be able to see if I can recreate that. I have to see what was right with it and what was wrong with it. So I don't have those two things, right?
Is it possible that it's just not completed?
It
It's
is possible.
A final report?
It is possible, but I need you to order that come to me. And I don't think Ms. Jennings doesn't want to give it to me. But if you order that I get it, then I'm going to get it a lot sooner, I think. I'm not saying that Ms. Jennings is sitting holding it behind her back. I'm saying I don't now know what's going on. The FBI told her it was going to be in by March 31st. We hit our deadline to disclose our alibi. And all of a sudden now they need to redo something in the report, which shocks me because of the things they said that they relied on were things that already existed. So now I really need to know what they're relying on to do this report. And I really need to see the analysis, and I really need to see the final report.
Sure.
I have to react to it.
Since we're talking about this, Ms. Jennings, do you want to just respond to that? Whether or not this is still a work in progress or what's going on?
Right, Your Honor. As I know right now, that report is not in its final form. And it has gone through a peer review process. My understanding is it's still in that. I have been told that yes, it's not a matter of redoing anything, but as they receive additional information, they just want to double check their work. They want to make sure that when they get the final report, it's accurate. So we are still waiting for that final report to ensure that it's accurate. And as soon as we receive it,
I'm sorry. You have a time frame for that? I told you when they expect to be finished?
I don't have a final time frame. They originally told us it was projected to be completed by June next month. So I'm hoping to get it within the next month.
All right, thank you. Appreciate that. Sometimes it's easier just to sort a particular issue at the same time.
Some of the hot ones, it might be, Your Honor.
Yes.
Your Honor, I do think we have the regional tower list now, so I think we're good with that. On item number 244 and 245, we have those documents now, so we're good there. Moving then to item 248. This is the drive test data, the mapping data. The court heard pretty extensively that we've received this in two places. We've received some early on, and then we received a lot more recently, but it appears to still be missing some. Asking the court just to order that we receive the entirety of all drive test data that was conducted by Agent Balance or anybody from the FBI. $249 is anything that exists after January 6th of 2023 for the drive test data. That's number 249. And so I would ask the court to order that to the extent that it exists. Would ask that it be ordered to be produced. Item 250 is the training and certification records for Nick Balance and Sean Kennedy relating specifically to the use of the Gladiator or the GAR. That's the item used to conduct these drive tests. Your Honor, I think that we gave the court a transcript of testimony of Nick Balance that occurred within the last year. And that transcript had highlighting on it, so the court didn't have to read the whole thing, but to look at how many times the training and experience was relied upon by this expert, and that expert's Nick Balance. And if he's going to be a testifying expert, the discovery rules allow for us to have their training. We asked for it specific to this Gladiator because we know that's going to be a big part of his testimony. So we're asking the court to order that we receive his training and certification records relating to the GAR. Similarly, now we'll talk about the GAR unit itself and its calibration records or its certificates that it's in compliance. The court just heard the testimony from Mr. Ray about how important that is, that often they get tired, things go wrong with them, and they get restored to service. We do have 2 certificates, but what we need is what Mr. Ray called the bookends, so we need the other side. We know that it came in non-compliant and then it was restored and went back out. We don't know what happened after it was used. We don't know the next bit of calibration that it went through. We don't know how it checked out. So we need the full copy, the bookend copy of the calibration reports.
This is still in 250.
That one is 250, yes. Sorry, Judge, I think that might have been in 251. That wasn't 251. 250 is the training records for the agents, and 251 is for the calibration records for the instrument. I apologize for that. 258 is a request for all information, all data, including all expert reports that the state has relied upon in developing the affidavits in support of all warrants.
But that's like a big one.
It's a big one, and the state responded with an answer saying, these are the things that have been relied on. I'll tell you what my concern is, that there are things maybe in computer files, things on somebody's desk that haven't been turned over yet. So I think the court ought to order that the state make sure they've given us everything that was relied on for every single one of the warrants. Ms. Massa indicated to the court, and I know that other members, I think Mr. Logston has indicated that we're going to have motions to suppress. And so we want to make sure that we have all of the information. Possibly it would answer questions so we don't have to have this many. But
So we don't have to what?
have quite as many motions to suppress.
Okay, thank you.
That's not a promise.
I I understand.
All right, Judge, let's talk about the fifth motion to compel. That completed the fourth. The fifth motion to compel, we are not going to talk about the 15th request for discovery until this afternoon. So my comments will relate to the supplemental request for discovery, number 12, number 13, and number 14.
12, 13, 14.
Yes. In request number 259, number 260, 261, 262, and 265, the state has let us know that these are coming. They responded on May 10th and said these are coming. They don't have a problem. So we're asking the court to order them to be disclosed to us. I think these are some that aren't going to be available for a while, but I think the court ought to order it. The state doesn't seem to have an objection to us having them. The order will mean we don't have to come back if something doesn't get through to us.
Okay, can you give me those numbers again, please?
Yes, I can. It's number 259, number 260, number 261, 262, and 265.
Thank you.
Your Honor, 289 related to communications between Detective Kane and the WSU officer talking about why to launch risks. I believe that that's been covered. Kane testified today that we have the instant messages and there was only a phone call and that was it. So to the extent that that's the very end of it, then we're fine. And so I think we are on that one. Item number 299 is called a tips lead sheet. And that's something that's referenced during the course of in the discovery. We were asked for an example that was sent to the state. I'm just going to ask the court to order that be disclosed to us. Number 300 relates to emails, notes, and other communications. The state's responded with 3 separate AV files, and I'm going to ask the court just to order that they all be given to us. We may have them all, but I'm going to ask that the court just order that just to be sure that we have them. Well, Your Honor, I take that back. I spoke with Ms. Jennings and I know there's one area, I'm not going to talk about the area, but I know there's still one area that we don't have. So I'm going to ask the court to order that all emails, notes, and communications be produced to us. Your Honor, the next item is the CAST certification and training for Nick Balance. And for many of the same reasons that we asked for that for the Gladiator, we need to have his training records. He's going to come in as an expert. The discovery rules cover this. You can see an example of him testifying as an expert in the transcript that I provided.
That's not covered by 250.
250 is the training related to the Gladiator specifically. This one is relating very specifically to his training for his CAST work and certification for his CAST work.
I'm sorry, what was the number for that training?
I do not think
That's 300.
that one's not 300. Let me find that one. I didn't write that number down. Give me 263. Count to save the day.
263.
And 264, I believe, relates to Sean Kennedy. Yeah, he's another FBI CAST person. And I am now at still. Your Honor, items 274, 275, and 278 have been provided. Item 287 relates to a new expert, a blood spatter expert that the state is working with. We're told that that's going to be available in June. It doesn't seem that there's an objection. Would ask the court to order that be provided to us once received by the state. Request 289 we have. We're now at the 13th supplemental request for discovery. And that one is 302, item 302. That's similar to several others. So I'm going to hold the argument on that for a minute. I'm going to let the court know that items 303, 304, 305 have been provided to us, except there's going to be some raw data provided to us. And to that extent, would ask the court order that we receive the raw data that those have otherwise been complied with. Items 306, 309, and 308. Those, the response from the state has been that we've now worked through the 2E process. That letter's been given to the FBI, and so we may get those by early June. So we ask the court to order that those be produced. I don't think the state's objecting to those. They just don't quite have them yet. 307 has been provided. Your Honor, 313. That is, those are the Department of Transportation cameras. We heard testimony about that last week, that there was a letter preserving still shots, but not any video was available. So I think that that's been complied with to the extent that it can be complied with. 314 was the email communication, and we received that, so that's been complied with. 316 and 315, I believe, are also subject to the 2E letter, so would ask the court order those be provided as soon as they're received. And now moving on to request 317, 322, 319, 320, 321, 323, 320, and 324. And then picking back up with 302. Those are all surveillance camera items that we've requested. We're asking the court to order Moscow Police Department as the custodian of these things in this case to do an inventory of what's there. You heard last week that Detective Mallory said, I don't have the videos, those aren't my responsibility. You heard today Detective Payne said it's Mallory and FBI agents. So we take Mallory out of the equation. He says, I didn't do it. I can't tell you where these videos are. I don't know who the FBI agents are. So first, I think the court ought to order that that be disclosed to me. The second offer was that I can go to the Moscow Police Department evidence room and go through hundreds of hours, thousands of hours of videotapes, and that's just not reasonable. These are videotapes that have been collected in the course of this investigation. You heard Detective Payne say that when he looked at cameras on South 95 and the other road south of Moscow on the date in question, and in conformance with what he alleged in his affidavit of probable cause to arrest Bryan, he looked at those videos and he didn't find a car. That screams stuff that's exculpatory to me. I need to know where these videos are. They were collected. The court can see that from the reports that we put in the packet of evidence. The court knows they've been collected, but nobody can tell me where they. And I need to have I don't physically have time to go watch thousands of hours in Moscow Police Department and be efficient with the case. But if that's what I have to do, I guess I need the court to tell me that's what I have to do. I think you have the ability to order that there be an accounting of all of these videos. Keep in mind, what we heard today was exculpatory. So there has to be a duty to categorize all of these videos and get that information to me. Go find these videos that other police officers turned over to Moscow Police Department that are in relevant areas. That's just critical, and that needs to happen.
So I did look at a long list of videos that were provided to the defense that said there was nothing there, or the camera was broken, or so there was some kind of inventory there. I mean, you saw that, right?
Yes,
Yes.
yes.
So what you want now is just a complete inventory of all of the videos that they obtained.
That would be appropriate to have that, but there are specifically named videos in this fifth motion to compel that we specifically want the videos. We know they're there. We've read the police report. We've
Okay,
given
and
them to our copy.
if these 317 through, I don't know, 324, you're saying that those are specific
There's a little,
videos that you want, that you think are in this inventory.
well, I don't know if they're in that inventory. I don't have them. I know they were collected and given to Moscow Police Department. I want to know where they are. And we listed out in 317, in 322, 319, 320, 321, 323, and 324 different locations that say we collected these. We gave them to Moscow Police Department. That's what I need to know. Where
You
are
didn't-
they?
You didn't get any of these videos of this list that you just gave me.
No, of that list I gave you, I did not. There was also one that I asked to be included. I'm coming back to that number. It's 302. We did get a time frame on the day before the incident. And so I need to know where the time frame after the incident is.
Okay,
Okay,
thank you.
thank you, Judge, for that. And I'm close to being done. Number 325. The answer was that if there was communications, it would have been a call. So that one's fine. We're good with that one. Number 326 is Uber logs between Detective Mowry and Uber company. They've been provided to us, but I can't get into them. They're password protected. Miss Jennings and I have been trying to work that out. I think she'll continue to try to help me, but to the extent that it doesn't work, I'll need a copy that does work in some form. J has to do, or I'm sorry, 336. 336 has to do with records, and I believe that Miss Jennings has provided or is providing a police report that will indicate these records don't exist based on an interview that was done. So we don't need to do anything with that one today. And I think the rest of them, 335, 336, 337, 338, and 339. The state has indicated that we've been given everything there is and nothing else exists. This all has to do with vehicle identification, and we're talking about identifying a car in question from a video as being a 2011 to 13 Elantra. They say we have it all. So if we have it all, that's great. I just don't want any surprises. Again, Your Honor, and we think the court should order the things as we outline. They are material to the preparation of our defense. I would remind the court that relevance is the standard of whether it gets in front of the jury, but it's a different standard when we're talking about materiality. That was talked about in the Pendleton case, and I know the court's familiar
do
with the
understand.
Pendleton case. The court wrote about that in a previous order.
Yes.
So I'll leave it at that and just request that the court forward these things so we can.
I'm at that list, at the end, about the, identification of vehicle. You're saying that they have provided that to you, but they're telling you that's all they have.
Yes, there are specific items that they say, we gave you everything that's there. The rest of these items don't exist. It has to do with cameras and camera angles and different things like that. It's spelled out in the fifth motion to compel.
Okay.
I just don't want to be surprised.
You just want to make sure that if they find something else, they provide some supplemental response.
Well, I'd be concerned if they find something else after
Right.
they said nothing
Well,
else exists.
they're shaking their heads right now, but you never know. So, okay, thank you very much.
Thank you, Judge.
Ms. Jennings,
Thank you, Judge.
it's a lot of stuff there.
Yes, and I'll try to make this quick, kind of go through each of these items, that are still out there for discussion. But just to give you, a little bit of perspective of what all has been provided to date. The state. has
Well, I
given-
rest assured, both sides, that I have gone through page after page after page after page. So, yeah, I understand. I have some perspective about what's been going on and how hard, both sides have been working. So,
And
Go
just to
ahead.
give a little context, why this isn't just so simple. To date, we've given 15,691 bait stamped pages of discovery. So for a little context, this is a 2-inch binder. It would be about 39 of these. We've given 13,758 bait stamped photographs. That's about 34 of those binders of photographs. We've given 911 AV dumps. Those are digital files. In addition to a massive hard drive, about 50 terabytes full of discovery. And that includes audio video from about 285 interviews, 15,000 video clips from approximately 79 businesses, 8,000 video clips from approximately 10 residences, 417 files containing call detail records, multiple terabytes of records for 11 computer devices, 17 cell phones, multiple social media accounts, and 4 tower dumps.
Or, excuse me, Ms.
what
Jennings.
was the last one?
4 tower dumps. In addition to records regarding well over 17,000 tips. We've given multiple terabytes of records in response to the 71 grand jury subpoenas, as well as the 101 search warrants that were done in this case. We have facilitated the defense viewing the physical evidence on multiple occasions, as well as facilitated additional DNA trace evidence to be examined at their request. We've had a consistent pattern of loading up discovery and providing a hard drive to the defense on an almost weekly basis. And just to be clear, we're going to continue to do that. As we receive discovery, we review it, we load it on our hard drive, and we give it over. Now, going specifically through each of the requests, we've already dealt with in the fourth motion to compel. Item 214, we've already argued. Item 219, we've already complied with. The CAPS biz logs. You heard the testimony, and what we know and what the judge heard testimony for is that CAPS biz is just a software program that allows investigators to put in like the records received from a cell phone provider like AT&T into a software program and then kind of visualize. Detective Mallory testified he got the raw data set from AT&T used the default settings for the times in question. It produced a map. He took a screenshot of that map. We provided that screenshot. He only did this in response to our request to provide a visual for the grand jury. We've been told that optional session files were not created or saved, and that this item just simply doesn't exist. In the current version of CastViz, the user settings aren't automatically saved in an exported session, but instead it just returns to default settings. I asked Detective Mallory about this. He advised us that he used the default settings. It doesn't take much time or effort to redo this, which is why he didn't save those logs. That's his normal practice. He just saved the screenshots and we've provided that. We agree, we will double check. We're doing that throughout all of this. To our knowledge, there are not tower documents that were relied upon, but we will double check and inquire, and if that exists, then we will turn it over. 226 has to do, well, first the request was for the AT&T Hemisphere program, and then it detailed several other things below it. And we were told they didn't use the Hemisphere program. And you're right, language is important as to exactly what's being requested. And now after a series of back and forth, they're saying that they want AT&T timing report. We have been told if that's referring to timing advance records, those records don't exist. We do have these location records, the DBOR records, and we've given those over. Now, the second part, it says that investigators recently obtained certified records from AT&T, and that'll be disclosed in upcoming discovery production. My understanding is that that's not related to the above. It's not related to Bryan Kohberger's records. It's related to other records that were done later for other folks. But we will be providing that in the next production doc. Next is 228, complete copy of all materials relied upon Corporal Payne. To our knowledge, we turned all of that over. We have given the documentation of correspondence between our cast agent Balance as well as with Detective Payne. And he testified today that the only other communication, they were together. So they were just relaying things verbally. And that he was including that information in his report.
Can you give me the numbers too? Because I'm trying to keep track.
I am on 228. 229 has been complied with. Now we're at 242, a complete cast report. We've already discussed that.
When you say complied with, does that mean that both sides agree that it was complied with? Or is it that you saying that you complied with that, but they are still asking for it? I just want to, speaking of language.
Well, I can't speak for the defense, but to our knowledge, we have provided everything that relates to the MAID data.
Okay. I just want to be clear about that. So if both sides agree that this is done, we don't need to keep arguing about this. But if the state is saying, well, we've complied, but they don't agree with that, then that's something I have to deal with. Ms. Taylor.
Your Honor, there's so much here. So the clarification on this is they did give us MAID data. I've been working with our expert and we think that all the data is there, but part 2 of it has to do with the Babel information that's coming. That's in the 5th motion to compel. And
That's a great.
It's a good one to remember. Yeah.
Yes.
And so I need that to put those 2 together. So I think the MAID data we have, I need to reserve though and say once our experts had full time to look at the MAID data, once we get the Babel stuff as well, then we may have a problem. But they did do a disclosure. For sure they did do a disclosure. I just can't say it's all of what we were looking for quite yet.
All right, so some of these we might come back to me to say, okay, where there's something missing or everything's fine.
And I will speak with Ms. Jensen if I notice that ahead of time too.
Okay, thank you.
243 relates to the final draft of the past report. 244 is done. 248, there's still some questions about. I will say that Ms. Taylor reached out to me last week, letting me know that they believe there might be some missing pieces there. I reached out to SA Balance, asking, he was at a training all last week. I've been told he's looking into it to see if there is additional information, then of course we would produce that. That's all I know at this point. 249 is related to the above. 250 to the state belief, that's been done. And 258, again, this is a very broad request. If there's something specifically that they're looking for, that would be helpful. But as far as the state's concerned, we've complied with this request. We've given you the returns for all of the 101 search warrants that were done, as well as the affidavits, which detail exactly what the investigator relied upon in order to obtain those search warrants. Again, if there's something specific that they're seeking or looking for, if they can provide that to us, then we will inquire. Now we move on to the fifth. Items 259 through, well, 259, 260, 261, 262, and 265. Yes, our answer is that we have inquired. We've been told that this is coming. The employee responsible for these items is out on medical leave for about 6 to 8 weeks. We still have probably another month left before she returns. And then would need time for that to be completed. But we do intend on giving this over. As we've done already, as we get it, we turn it over. Item 289, this is completed. 299, temp lead sheets. State has provided information for well over 17,000 tips in this case. We've been advised by the FBI that they believe they have provided all information related to tips. Now, I'm unsure if there are duplicates of this same information. We will inquire, but substantively, it's our understanding that they have all the information for the 17,000 tips. But yes, I will inquire and see if there's something, a tip lead sheet that can be easily provided. 300. This has, for the majority, already been provided. They already have the ISP and PD emails. I've talked to Ms. Taylor about another certain section of emails that she would like to see. I will inquire about that, and if they exist, we will turn them over. 263 and 264 have to do with CAS certification and training records. I can tell the court we're going to comply with this. We're not at our expert discovery disclosure deadline, and we're just not at that point, but we will be. And we plan on giving this over on anything we intend to rely upon. 274, 275, 278 have all been done. 287, this is an expert analysis. We haven't received it. We are expecting to receive it sometime in the next month. As soon as we receive that, we will discover. 289 is done. And starting with 302 is when we get into all these different surveillance videos. we have provided them a list of all the videos as they're labeled and as they're stored at MPD. Now, yes, we will do our due diligence to make sure that what we have is turned over. To date, though, and we'll continue to do that. To date, we have located a Watson Carey construction video, but the only thing we've located is one that covers from about 9 p.m. on the 12th till midnight. We'll continue to look for what they've requested. And as soon as, if it's located, we will turn it over. 303 has been completed, 304 has been completed, and 305. The next series, 306, 307, 308, 309 are all part of the 2-week process. As detailed in our response, we've been told by the FBI that it's going through their process. And we're hoping to hear something back about whether or not these are approved and when they're going to be provided in early June. 313 is done, 314 is done, 315 is part of, again, the 2-week process, as well as 316. Again, we should know more early June. Back to videos, 317. The first thing they asked for is this US Bank video. That's been provided. Ampersand, to our knowledge, it doesn't exist. Again, we'll do our due diligence to make sure. If it's located, we'll provide it. One World Cafe does not exist. And 9 to 5 is actually US Bank, and that's been provided. Red Star Coffee, we have, and 319, 320, 321 are all ones that are still outstanding. We'll continue to try to locate those. If they exist, we'll turn them over. 324, 325, 326 have all been complied with. 334 does not exist, and there will be a supplemental report to that effect. 335, 336, 337, 338, 339, 340 have all been complied with, and that gets us to the end of the 5th for this hearing.
Thank you. Any response?
Your Honor, just really briefly, I want to talk about item 226, the Hemisphere program. Ms. Jennings asked me if we meant the timing advance program. That's one and the same. I just heard her say that those records don't exist. I just need to be clear, if they don't exist, then I need to know that. If they do exist and they were used, I need to have them. She mentioned that item 250, that's the balance training records that we have. That we don't have that. That balance training records related to the use of the Gladiator machine. We don't have those. 251 is partially complied with. That's the certificate on whether the Gladiator machine was working appropriately. We need the follow-up the next time that machine was put back for testing. Both machines, there were 2. 263 and 264, Balance and Kennedy's cast training records. I'm happy to hear that I'm going to get those. With regard to the videos on exhibit RR that the court has under number 21, this is where the business said they already had given over their videos, and Ampersand and One World Cafe are both listed on that as well. So they were given to somebody to go to Moscow Police Department at some point in time. And that's it for clarifications for me. Thank you.
Great, excellent. Anything else?
No.
Okay, great. All right, a lot of work there for all of you, maybe a lot, but why don't we take a break? And I mean, we're supposed to start the second chapter here. Why don't we start at 2:00? That's okay. All right? So we'll recess. Thank you.